Morning.
Morning.
Just
May-
just 1 second. Let the. Huh? What you going to say? Yes.
May I please, I beg to mention item number 28. In this case, I am going to file an application to include Accountant General.
Item number.
28. May I say that it may be taken up
Yes. When do you want it?
after vacation anyway.
As prayed for by Mr. S. Kotoki, learned counsel appearing for the petitioner, relist after 2 weeks on a date to be fixed by the registry to enable the petitioner to take necessary step to implead
Accountant General.
the Accountant General's
Party respondent.
as a arraigned party respondent.
May I please, Lordship? But this is a matter of court number 19 I am mentioning. My lord, this matter is a contempt matter. The process is going on. My father died while he was in service.
What
It
do you
may
want?
can be listed on Monday, madam.
But that is already there today in the list.
No, it is not. It is motion matter.
Is it in the list today? No. You want this matter to be
listed on Monday.
all right. Any prayers for listing? Please give it to the court master. He shall accommodate as far as possible. Yes.
Listing of a writ petition.
I just said. No, do you want me to repeat it? Would it become more better? Yes.
I beg to mention item number 5 with the consent of the petitioner, Lordship. We have received the Lordship, the instructions in the matter. We need some time to file the affidavit, Lordship.
Item number
5, Lord.
5.
Consent of the petitioner has been taken, Lord.
Huh?
Consent of the petitioner has been taken.
You are for the respondent.
Respondent are the CGC, Lordship.
As prayed for by Mr.
A.R. Tohvinda.
A.R. Tovilda, learned counsel appearing on behalf of Mrs. R. Devi, learned CGC,
Lordship.
comma, with consent from the other side, relist after 2 weeks on a date to be fixed by the registry.
Wait, with the Lordship, I beg to mention item number 18, Lordship.
Item number
18.
18.
18, Lordship. We have filed one affidavit in opposition against the IA number 2842.
What do you want?
Lordship, the matter may kindly be fixed at 2, Lordship. We have filed the affidavit today only. And
All right. If you have filed the affidavit, it will come.
Let it be on Tuesday. I have urgency. That is my petition seeking vacation of the stay order.
All right, then Tuesday.
Lordship.
In item 18, you write, heard Mr. P. Bharadwaj, learned counsel appearing for the applicant. Also heard Mr.
US Bora.
U.S. Bora, learned counsel appearing for the higher education.
No, Lordship. I am for the
Private respondent.
Yes,
Stop. Mr. So-and-so, learned counsel for the private respondent, submits that he has filed an affidavit
in affidavit in opposition.
in opposition. However, the same is not on record. Let registry verify and place the same on record. Relist on Tuesday, so-and-so date.
Lordship.
Yes.
Much obliged.
Yes, Mr. Sharma?
21, 22, and 23, my lord.
Yes.
In fact, 24 is also tagged. My lord, the matter was tagged with my lord, Mr. Nayar's court, my lord. In fact,
List before appropriate bench.
I'm grateful, my lord.
As prayed for.
Lordship, item number 17, kindly fix the matter at 2.
Item number?
17.
What is so special at 2? There are already a matter fixed at 2. 17, I think amended cost, the cost title was supposed to be given. Have you given?
My lord, 17 was in regard to that disciplinary proceeding, my lord, where the inquiry officer had already come to a conclusion, my lord.
You are there in that matter?
Yes, my lord. I'm the petitioner, my lord. Your lordship had sought a small paper book in regard to the judgments cited by us, my lord. We had provided that.
So shall we have it at 2
I'll
o'clock?
leave it to your lordship's convenience. I have nothing against my senior counsel's prayer, my lord.
All right, at 2, but there's another matter fixed at 2 after that.
Okay.
I'm grateful, my lord.
Miss, please, Lordship. Lordship, back to mention for listing 2 WPC, my lord, for additional conditions.
I have just said that any listing prayers you.
Lordship, I beg to mention item number 19.
Yes, what do you want in 19?
Lordship, on the last occasion, we had made a submission that matter may become infractious, Lordship.
So
So we need
has
some
it
time.
become infractious?
So we need some time, Lordship, to take.
As
proper
prayed
instruction.
for, relist after 2 weeks on a date to be fixed by the registry to enable the petitioner to obtain instruction as regards whether the matter during the pendency of the proceeding has become infractious. Yes, next.
Okay.
For motion item number 33.
May I pray your Lordship?
Lordship, can it be taken after some time, Your Lordship? Mr. B. Kaushik will be here, Your Lordship. After
Mr.
some time.
Mr. Chaudhary? After some time,
My matter may be hard to them.
I cannot give you that guarantee. I have
Yes,
not
because
seen the file.
Because
It's a motion matter. She's asking for some time, so we are accommodated.
Obliged, Your Lord.
On admission, item number 35.
Heard MSRS Chaudhary, learned counsel appearing for the writ petitioner. Also heard Mr. S.C. Kayal, learned standing counsel, Assam University. And MS Esna, is she there? Who's there for UGC today?
Your Lordship, Zara Majumdar appearing on behalf of P. Agarwal.
MS so-and-so, learned counsel appearing on behalf of Dr. P. Agarwal, learned standing counsel, UGC for the respondent number 5. The brief facts of the case is that, no, before that, the petitioner who is serving as an assistant professor, right, Ms. Chaudhary?
Yes, Your
In which department?
Department of Hindi in the Difu campus of
In the Department of Hindi, Assam University,
Difu campus.
in the Difu campus, in the respondent university, challenges the continuation and repeated extension of his suspension during pendency of disciplinary proceedings initiated against him on charges inter alia of sexual harassment. Full stop. The brief facts of the case is that the petitioner was placed under suspension. Where do I get the initial suspension order? Page 50?
Page 41, Your Lordship.
41. Was placed under suspension on 18/12/2024. Pending disciplinary proceedings. Against alleged sexual harassment at workplace. Stop. Charge sheet issued is that page, next page.
Yes, Your Lordship.
Within the initial period of 90 days, on 21/2/2020, no,
12/2.
on
12/2/2025.
12/2/2025, comma, the memorandum of charges was issued to the petitioner.
Which was received by me.
But that is okay.
Lordship, that is a very important.
Which was received by the petitioner on 21/2/2025. Stop. But it is within the time limit.
Yes, definitely, yes.
The suspension was thereafter extended. Next, second extension when?
Page 73 on 10/3/2025.
Page 73.
3.
On 10/3/2025. Within the That is also before the expiry,
Yes,
before
before
the
the
expiry of the 90 days period of suspension. It is a specific case of the petitioner that the said extension was done without passing a reasoned order. The MS so-and-so learned counsel appearing on behalf of the writ petitioner relies upon Ajay Chaudhary versus Union of India, reported in 2015, volume 7 SSC at page 291, wherein the Honorable Apex Court has held that suspension beyond 90 days must be supported by a reasoned order. Upon due review, she further submits that during the pendency of the instant writ proceedings, despite the disciplinary proceedings having been concluded as per the submission made by the respondent in the in one of the proceedings before this court, once again extended the suspension.
Additional affidavit, Your Lordship, page,
Yes, I'm just trying to find that. These
page 172. नहीं यार, sir,
On-
वो कौन सा? That's
on
174.
3/9/2025.
Yes, Your Lordship. 174.
She further contends that she further contends that though the second extension is also before the lapse of the 90 days period, however, there are no reasons recorded therein for extending the service suspension. She accordingly submits that the entire submits that the extensions being not reasoned are vitiated, and hence the same warrants interference by this writ court. Stop. Correct? These are your submissions. Per contra,
Because I also relied on that Prasanto Datta.
That's all right.
That's fine. As per your
per
lordship.
contra, Mr. S.A. Kayal, learned counsel appearing for the respondent, submits that under sub-rule 6 and 7 of Rule 10 of the CCS, Central Civil Services within bracket classification, control and appeal rules 1965. The respondent is not required to record any reasons in writing for extension of suspension beyond the stipulated (90 days) period. He however submits that he further submits that in the present case the disciplinary proceedings has been concluded. He further submits that since the rules does not require recording reasons. Therefore, the impugned extensions are being in terms of the applicable rules cannot be said to be warrants no interference from this court. Despite, stop. He further submits that the decision of the apex court in the case of Ajay Chaudhary Supra does not apply to the facts of the present case in view of the aforesaid rule. On the face of the aforesaid rule. Edit করে দিম তোমার।
Lordships, if I may just, I apologize. They had also relied on their own annexure 13. And he had placed a document yesterday.
Annexure 13.
Of their affidavit in opposition. And he had also placed a document yesterday, which your lordships have kept on record. That document also has no reasons recorded in the, because that was the doc, if your lordships will turn to page 154.
Annexure 13.
Yes.
Page.
Page 154. This was the two members.
But that's all right. You see, no, I'm not going into that so much because it's an admitted, it has been admitted.
Yes.
He has admitted that fact.
Yes. Then I'm.
Correct.
Apologize.
He further submits that compliance with the statutory framework is sufficient and judicial interpolation of further requirement is unwarranted. Stop. Heard, perused. Okay. In order to appreciate the rival contentions, it is necessary to notice Rule 10.6 and Rule 10.7 of the so-and-so rules, which read as under quote unquote kutetu poridiba. A plain reading of the above provision shows that the statutory requirement is twofold. Number one, review of suspension by the competent authority within 90 days and thereafter before expiry of every extended period. Number two, and number two, any single extension shall not exceed 180 days. The respondents are right, next para, to right to the extent that Rule 10.6, 10.6 and 10.7 of the said rules do not expressly stipulate that reasons must be recorded in writing for each extension. However, this contention overlooks the binding law laid down by the apex court in Ajay Chaudhary Supra. Stop. In paragraph 21 of the judgment, the apex court held as under quote unquote paragraph 21. Next para. Thus, the law as declared under Article 141 of the Constitution of India is that every extension of suspension, though permissible under Rule 10.6 and 7, must be accompanied by reasons reflecting application of mind. Stop. The object is to ensure that suspension, which is not a penalty, comma, but an interim measure, comma, does not become punitive or arbitrary. Stop. In the present case, though the memorandum of charge was issued within 90 days, the subsequent extension of suspension i.e. on, yes, the first date,
10/3/2025.
10/3,
2025.
2025, including the last extension, i.e.
3/9/2025.
3/9,
2025.
2025. And one second, Ms. Chaudhary, in the first date to, within bracket,
Huh.
annexure,
Annexure G, page 73.
annexure G to
Page 73.
annexure G to the writ petition,
petition.
and the next annexure,
Annexure P to the additional. affidavit.
annexure P to the additional affidavit filed on such and such date.
On 15/9/2025.
15/9,
2025.
2025. কি বেরিয়ে লিখিল?
Within 90 days, subsequent extension of suspension, i.e. on 10/3/2020, including the last i.e. 10 and 2026.
Made even after conclusion of the disciplinary proceedings were made without any reasoned order. Stop. The so-called review, full stop, huh? Reference in this regard is made, no, apt at this stage to refer to the impugned extensions, which reads as under. I'm sorry, I'll need that date again. That page. 73. First to quote unquote page 73 koriba. Second to additional. I have that additional affidavit or page 174. Huh? And which is that annexure 13 you want to say?
Page 154.
That is of the
Of the affidavit in opposition filed by the
154.
4.
Yes. Reading of the aforesaid to extension, it is apparent that there is no reason whatsoever recorded in the aforesaid extension orders. Pertinent to refer to the letter dated 7/3/2025 enclosed to the affidavit in opposition filed on behalf of the
On behalf of the respondent, the university.
on behalf of the respondent university,
Remember 2, 3, and 4. 2, 3, 4.
respondent 2, 3, and 4, whereby the report of the two-member committee on review of suspension in respect of the petitioner was submitted before the Vice Chancellor of the Assam University, which read as under, quote unquote, to page 154. Reading of the aforesaid review also does not indicate any reasons for the extensions. Thus, the so-called review consists only of mechanical approval without disclosure of rationale. This is directly contrary to the mandate of Ajay Chaudhary Supra. Stop. The next paragraph. The submission that Rule 10 does not require reasons is untenable because statutory rules must be read in harmony with the binding precedent, with the binding exposition of law by the apex court, the rules provide the procedural framework, but the apex court has clarified the constitutional requirement of fairness, which obliges recording of reasons. Stop. The fact that the disciplinary proceedings have since concluded does not cure the illegality which was that order that disciplinary proceeding was over. Yes, yes. The fact proceedings have since concluded, which appears from the which fact establishes from the order of this court dated 14/8/2025 does not cure the illegality in continuing the suspension without reasoned orders. Stop. The legal consequence of such illegality survives for purposes of service benefits. Once the extensions are found unsustainable, the suspension is deemed to have lapsed on the expiry of 90 days from its commencement. The petitioner would therefore be entitled to claim consequential benefits such as restoration of full salary and allowances for the period after such lapse, continuity of service and other included benefits, subject of course to adjustment against any penalty ultimately imposed in the disciplinary proceedings. Next para. At the same time, it cannot be ignored that the allegations against the petitioners are of a serious nature, full stop. While this court has held the extensions to be unsustainable, the institutional interest of maintaining a safe and conducive environment in the university must also be safeguarded. Therefore, liberty is reserved to the respondent university to post or transfer the petitioner to any other campus. Campus, they said, na?
Yeah.
Campus. Is that a campus?
Just it's in China.
Any other campus or department of the university?
They can't be transferred to any department, you know.
So campus.
So campus.
Any other campus of the university. Stop. If so deemed, if so deemed, if so deemed appropriate, pending final decision in the disciplinary proceedings and thereafter. Okay, sir? Further, in order to ensure protection of the complainant and witnesses, it is directed that the petitioner shall not directly or indirectly interfere with contact or cause harassment to the complainant or any witnesses involved in the case. This protective clause is issued in exercise of the equitable jurisdiction of this court to ensure, of this court to balance, don't say ensure, of of this court to balance competing interest, comma, and shall not be considered as a finding on the merits of the allegations. Stop. The same shall not influence or prejudice the final disciplinary authority, final decision of the disciplinary authority or any appellate forum. Stop. Any violation of this condition shall entitle the respondents to seek appropriate orders, including revival of suspension in accordance with law. For the reasons stated, the writ petition is allowed. The impugned orders of suspension dated, Ms. Chaudhary,
10/3/2025.
So and so?
The extension order.
yes,
10/3/2025.
impugned extension orders of suspension dated so and so and so and so.
3/9/20.
With bracket or duta heri duta ridibha annexure geta are quashed, and it is declared that the suspension of the petitioner stood lapsed on the expiry of 90 days from the date of the initial order, comma, in absence of a reasoned extension as mandated in Ajay Chaudhary. Stop. The petitioner shall be entitled to consequential benefits, including pay and continuity of service. He's still there.
Yes, yes, of course.
Subject to adjustment in accordance with the final outcome of the disciplinary proceedings already concluded. Stop. Allowed, huh?
Diplomat. Lordship, just one thing, it is not Ajay Chaudhary, it is Ajay Kumar Chaudhary.
Actually, Ms. Chaudhary, in the initial we said Ajay Kumar Chaudhary so and so. Now when we say Supra, we don't say the whole thing.
The first time on itself, your Lordship has said Ajay Chaudhary, that's right.
That will correct it.
I'm deeply obliged, Your Lordship.
Item number 4.
This is that stenographer's case.
Stenographer.
That's it. Okay. Yes. I'm dictating the judgment, huh? Heard Mr. A. Sahad. Learned counsel appearing for the writ petitioner also heard Ms. M. Bhattacharjee, learned senior government advocate appearing for the state respondents. By way of this instant writ petition under Article 2 to 6 of the Constitution of India, the petitioner is assailing the order dated 14/7 is that dismissal order.
28th November 2008, annex, page 57.
No, no.
Annex 8.
The order that is under challenge is as removal order, isn't it? Removal from service. Which is that order? 14/7/2012.
Page 57.
No, no, your prayer says some 14/7/12. That's why I'm asking.
Oh.
Which is the order of removal? Impugned order of assailing the impugned order of removal of the petitioner from service by order dated 28/11/2008, passed by the disciplinary authority on the basis of the inquiry report. Stop. See your prayer, Mr. Sahad. Stop, huh? The brief facts of the case is that The petitioner was charged on 15 May 2004 for allegedly taking bribe while he was serving as stenographer UDA in the SP office Lakhimpur, North Lakhimpur, from one Dilip Gogoi, by giving assurance of appointment of his son as AB constable in Assam Police Battalion, and that he has also similarly collected money from other individuals, assuring them to give government job in police department. It appears that Ms. Bhattacharjee, there was one more allegation about some contractual work. Where is that? I didn't find in the main charge sheet. It was subsequently added. Some contractual work also was there. No? That I have read, Mr. I have heard you. Just have your seat, please. If I recollect some
Yes, Lord.
one document, no, that he had. So this is just two charges then, right? Okay.
This is gross misconduct and relation of
All right.
duty.
Stop, huh? Pursuant to the show cause notices issued and inquiry conducted upon the inquiry officer submitting report, comma, the disciplinary authorities accepted disciplinary authority after issuance of second show cause notice accepted the findings of the inquiry officer and the impugned order. Where is the impugned order? Page. Yes, Mr. Sahat, impugned order page.
This is annex 4, page 41.
No, the removal order.
Removal.
Page
57.
page 57.
Annex, right?
By order dated 28/11/2008, placed the inflicted the punishment of removal from service to the petitioner from the of the office of so and so, with immediate effect.
I got this one. This fake work orders, page 39, Lordship.
Page
39. Second paragraph. Lordship. During investigation.
One second.
First show cause notice, Lordship.
All right. I'll come to that. This is that statement of allegations. Against this, an appeal was filed, na? Thereafter, an appeal was filed to the appellate authority. However, the appellate authority, which order, page?
90 lordship. This is 14/7.
By order dated 14/7/2012, rejected the appeal. Situated thus the present writ petition. Stop. Mr. Sahat, learned counsel, appearing for the petitioner, submits that no definite charge has been leveled against the petitioner for which the inquiry stands vitiated. He further submits that the allegation contained in the memorandum of charges are purely of alleged criminal offences and are outside the domain of the employer. He accordingly submits that the impugned order of removal from service inflicted against the petitioner is erroneous and perverse. He further submits that, where is that rule? Where do I get that rule? Rule 9. Assam Disciplinary Service. That under Rule 9, of the Assam Services Discipline and Appeal Rules 1964, the charges framed against the government servant and the statement of allegation must be furnished. Under sub rule 8 of Rule 9 of the so and so rules, the disciplinary authority, the inquiry officer, as well as the disciplinary authority is bound to record reasons against each findings, and non-recording of reasons vitiates the proceedings. Stop. Correct? This is what, na, Mr. Sahat, this is exactly what you had said. On each charges, on each charges who had queried. Per contra, MS Bhattacharjee submits that. No, 1 second, Arvita. He further submits that the criminal case, which was pending against the petitioner for the alleged for the alleged offense of cheating and fraud, the criminal court acquitted him of the charges. Correct? There was an acquittal, right? Acquitted him. Stop. He accordingly submits that since the criminal court has acquitted the petitioner of the charges which is similar to the charges before the disciplinary authority, comma, the impugned penalty is warrants interference from this court. Stop. Now per contra. Ms. M. Bhattacharjee submits that acquittal of the petitioner by the criminal court does not automatically discharge him from the disciplinary proceedings. She submits that there being evidence before the inquiry officer establishing the guilt of the petitioner, the inquiry report warrants no interference from this court. Correct, Ms. Bhattacharjee? That's all your submissions? Stop. I have heard the arguments advanced by the learned counsels appearing for the contending parties and have perused the materials available on record. Have to refer to the first show cause notice dated 15/5/2004, which reads as under page 27. Reading of the aforesaid submission, reading of the aforesaid show cause notice, it appears that the allegation against the petitioners were twofold. One, that he accepted money from one Dilip Gogoi on the pretext of securing his son's appointment in the police department. And number two, that he fabricated and used fake orders in the name of the department to procure construction materials for his personal building work. Don't say building work. You also issued some fake work orders to the contractors and asked them to supply materials like cement, iron, so and so, and some other articles in the name of SP Lakhimpur and procured the same for your only personal use. Don't say personal building, personal use. Where do I find the inquiry report?
Inquiry report. This one, Annexure 5, Lordship, from page 44 onward.
Yes.
And 45.
Yes, I've got it. A memorandum of charges was issued along with the statement of allegations, and an inquiry was conducted in accordance with law. Stop. The inquiry officer, upon examining witnesses, including the complainant Dilip Gogoi, within bracket PW number 4,
PW6.
6, PW 6, and one contractor, Shri Nobokumar Fukan, PW number 7, held the charges proved. The contention of the petitioner that the charges are essentially criminal in nature and the criminal court has already acquitted the petitioner from the aforesaid charges, comma, the law is well settled that criminal prosecution and disciplinary proceedings operate in distinct fields, and the employer is entitled to hold a departmental inquiry into misconduct affecting service discipline. Refer B.K. Meena, to my citation to read him, 1996, 6 SSC 417. Coming to the challenge based on Rule 99 of the 1964 rules, comma, apt to refer, comma, Rule 9 of the so-and-so rules read as under Koiriba, quote unquote Koiriba. Huh? Rule 9, 8 Koiriba first thought. 8 and 9 dutai Koiriba. Huh? A reading of the aforesaid rule, it is apparent that the record of inquiry must include the definite charges and findings on each charge and the reasons therefore. It is further apparent that the disciplinary authority shall, if it is not the inquiring authority, consider the record of the inquiry and record its finding on its charge. Stop. In the present case, the relevant portion of the inquiry report, after discussing the evidence, reads as under, quote unquote, page 49, A to A. Reading of the aforesaid findings, it is apparent that the inquiry officer, after discussing the statement of all the prosecution of all the witnesses, including the PW6 and PW7, and as well as the statement of the delinquent stroke petitioner, came to the finding that he had issued some work orders, stroke supply orders to some persons by taking illegal advantage of his official capacity as stenographer without the knowledge of the then SP, and that he had also taken loan from some of the witnesses, giving assurance to pay the amounts within the stipulated time. Stop. The aforesaid finding does not appear to be mechanical, but a reasoned one reflecting due application of mind. Rule 9, 8 and 9 of the rules obligates the inquiry officer as well as the disciplinary authority. No, rule 8 ko pa, Now coming to the findings of the disciplinary authority. Yes, where is that finding? The disciplinary authority, where he simply forwarded it.
Lordship, page
Page 55?
Yes, Lordship.
Now coming to the findings of the disciplinary authority, which reads as under, quote unquote, page 55. Reading of the aforesaid, it appears that the disciplinary authority has not recorded any reasons against the charges and has merely agreed with the findings of the inquiry officer. Stop. Rule 9(9) of the 1964 rules obligates the disciplinary authority upon receipt of the inquiry report to consider the records of the inquiry and thereafter records its own reasons. Findings record its own reasons, own findings on each charges. Such an exercise is not a mere formality, it is a statutory safeguard to ensure that the ultimate decision is not mechanical, but a reasoned one reflecting due application of mind. Stop. In the present case, a perusal of the removal order dated so and so reveals that the disciplinary authority has simply accepted the report of the inquiry officer and proceeded to impose the penalty. There is no indication that the authority applied its mind to the evidence, nor that it recorded independent findings on the individual charges. This omission constitutes non-compliance with Rule 9(9), rendering the order unsustainable in law. Where is that Justice Bhuya's judgment you had cited, na? That Rule 9 is mandatory? Reference in this regard is made to the decision of the coordinate bench in the case of Debobrata so-and-so versus Government of Assam, reported in 2016, Volume 5 GLT 230 at page 230, wherein this court has held that any violation of Rule 9 will vitiate the inquiry paragraph 7 and 8 cut to me 7 and 8 to my relevant parabilic relevant paragraphs reads as under 7 and 8 quote unquote. Though this court does not find any merit to the challenge of the inquiry, however, the order of removal in view of the discipline in view of the however, the order of the disciplinary authorities inflicting so and so is found to be erroneous. Once the foundational order of removal is vitiated for violation of statutory rules, the appellate order also cannot stand. In view thereof, the impugned orders that to 28 or 14 the disciplinary and appeal are set aside. However, it shall be open to the disciplinary authority to proceed afresh from the stage of receipt of the inquiry report and pass appropriate orders in accordance with law after due consideration of the record and recording of findings on each charge. The writ petition is accordingly allowed in the above terms, no cost.
Deeply oppressed.
Item 1.
Yes.
May it please, Your Lordship. My lord, this is regarding provincialization of the post of the petitioner.
One second. After two disposal, you do
Yes,
need a
yes,
glass of
yes.
water.
It requires me, Lord.
May I please, your lordship?
Yes.
Lordship, on the last occasion, I was supposed to file the additional affidavit, your lordship. I have sent the affidavit for vetting, your lordship. Lordship will allow me some time.
By when?
Lordship,
By when will you file?
lordship, 10 days, your lordship.
It has not come back. So that means after the puja.
Let them file, they have already filed 2 affidavits. My lord, this is 19 years she has rendered service. Her name was, why not provincialized? That was also
You
not
file it
recorded.
before the puja.
Lordship.
Yes, yes.
As prayed for by M.S.D. Mushahari, Learned Standing Council, for Learned Standing Council Secondary School Education, relist, give a date before puja.
Yes.
On such and such date to enable her to file the affidavit which is said to have been sent for vetting.
23rd or 24th, my lord. 25. Obliged, my lord.
Item 2.
There was one motion, na NNB Chaudhary. What happened to that? Why are you calling admission before the motion? Huh? Is there any, Mr. Kaushik is here? I can see Mr. Chaudhary also. Yes, where is that motion?
Pending item number 33.
That's the only motion?
Yes. May I please, Your Lordship, my lord? Here in the instant case, my lord, there are 4 petitioner, my lord. They are, my lord, as per advertisement, they appeared in the TET examination, my lord. They have passed that TET examination, my lord. And there has been fixed for, my lord, verification of document, my lord. After the date has been fixed for verification of document, before that on 27/5/2024, an SOP was, my lord, they have published in that SOP, they said there are 2 qualifications, 2 types. One is the, my lord, main qualification, another is the additional qualification, my lord. And in respect of, my lord, main qualification, there are 13 documents, and there is a provision, and we are uploaded the document. So for additional qualification of concern, my lord, nowhere it is stated that it will be uploaded at the time of, my lord, form fill up, my lord. Then what happened, my lord? And SOP 27, SOP was my lord, published, my lord, 27/5/2024. Sorry, my lord. 20, my lord, SOP was issued, my lord. On that particular SOP.
What is
25.
challenge, Mr.
Yes, ma'am.
Mr. Chaudhary?
My humble, I'm cutting short, my lord.
Just what
ma'am.
is the challenge? Then you can
Yes, my lord.
go on.
My challenge is that, my lord, they have, my lord, rejected my lord, rejected my application on the ground that educational qualification I have not, my lord, uploaded at the time of form fill up, my lord. That was the ground of rejection.
You have not
Uploaded the additional qualification that
uploaded
yes, my lord.
the additional
Yes, my lord.
qualification,
Yes, ma'am. That education criteria, my lord, not qualification.
additional criteria
Criteria, my lord.
at the town of
That, my lord, if I am reading in my English medium school, I have to take diploma from the, my lord, Assam Sahitya Sabha, my lord. And I acquired the degree in the month of 2024, my lord. But I acquired the certificate February 2025, my lord.
So
11 to 20.
at the time of uploading,
Yes,
you
yes,
did
yes,
not
sir.
have it.
Not have it.
Admittedly, you did not have it.
You did- This no, over there, this is not required to upload, but this is not the mandatory condition.
No, but admittedly, at the
Yes, ma'am.
time of uploading, otherwise you did not have the certificate,
Yes,
though
ma'am.
you acquired it.
Yes, madam.
But because you got the certificate
Yes, madam.
later, now you
Yes,
have it.
madam.
Correct?
Yes, madam.
Now, what is the requirement under the?
I am coming, my lord.
Ah.
Required under this rule, my lord.
Hmm.
Nowhere it is stated except this 13 document that educational qualification, education, B.Ed degree, and other degree. They have. You also come to page 43.
43.
Document uploaded as mentioned below should be.
This is part of what, Mr. Chaudhary? This page 43, this part?
This is part of my lord, advertisement, my lord.
Advertisement.
Yes, madam.
Okay.
Advertisement started from page annex to page 39.
Okay. Page 39.
Yes,
Yes.
ma'am.
This is the
Yes,
advertisement.
madam. Passport size color photograph, HSLC marksheet admit card, HSLC marksheet and certificate, degree, course provision, return marksheet, so, postgraduate marksheet, certificate in case of then 50% mark graduation, any other marksheet and certificate of higher education, B.Ed degree, caste certificate.
This is not there.
This is not there, madam. And that
Where does this come from?
it 43. This is come from, my lord. If your lordship go to the, my lord, page, my lord, 40.
Page 40.
Yes, my lord. My lord, there is your lordship on page 39, my lord, before that.
39.
Yes, my lord. Then minimum educational professional course for direct recruitment postgraduate teacher A. A is the art and science. Then, my lord.
Hindi.
A, my lord.
A is art science, B is Hindi.
Hindi, my lord. That
Yeah.
has to be, I have to, my lord, possess.
No. What do you have to possess? I'm not getting this. This you explain.
Yes, I'm coming, my lord.
Huh.
A and B, I have possessed, my lord.
You
At the time
you
of- at
have
the-
that.
I had that
You
time-
have these minimum educational and professional
Yes,
qualification.
my lord.
And you are for what, which subject are you applying for?
I am applying for Hindi, arts and science.
Or both?
Then my lord, comes the 40 my lord.
Yes. In
my lord,
addition,
in addition to the requisitional professional qualities as per sub rule 10.5 Assam secondary admission satisfy in Assamese medium school SSLC equivalent subject or have diploma of Assamese, that is my lord, language by the Ahom Haitya Sabha, read up to SSLC in Assamese medium school. That certificate my lord, after the advertisement, subsequently I acquired, I deposited my lord. And my lord, document which has been mentioned in 43, my lord, every document I have given.
in case of SMEs medium school,
Yes,
the
sir.
candidate must have passed HSLC or equivalent examination with Assamese language as one of the subjects, or have diploma in Assamese language issued by so and so, or read up to the so and so level in so and so.
Yes, sir.
But this is not there in the documents.
This is not in the document. That is why divisionment interfere in the matter, my lord. Single bench, similarly situated person petition has been dismissed by this honorable court. Then matter has been filed before the divisionment, similarly situated like me, my lord. And my lord, in that case, said that you have to not mention provision for uploading that particular document. So he has to produce at the time of my verification of document. At the time of verification of
Where is that
document,
order?
annex. I direct
What it is that you want today from this court?
that my lord, interim order passed by the division. I may be.
Where is that order?
Yes, my lord. 129, my lord. Yesterday they said, my lord, to take the copy of the my lord, petition repetition. I also take the my copy. In fact, you will also go to the petition order, my lord. Everything.
It's all right. I don't want to
129.
go that far.
Yes, my lord. Page 129. Have a look at it. This
Yes.
is a division bench order, my honorable division bench order. It was started from my lord.
It's all right. Till the disposal of these appeals, the
Yes,
post
my lord.
equal to the number of the
Okay.
applicants in all these so and so shall be kept reserved, but the process
Yes,
of
my lord.
continue. Qualifying the merit, then there will be no requirement. The recruitment
Yes, sir.
process. Yes, Mr. Kaushik.
But because this perhaps would be applicable for them also. But
Huh?
I would like to correct the facts, my lord.
No, you see, I'm not hearing this matter right now.
Because
This
the
is only the because you see, prima facie, this is not a
No, but-
document which you have set for uploading. Correct? And it is also not a case that the petitioner does not have this document. The
No.
petitioner may not have had it at the time of uploading, but your requirement doesn't say.
That's what not the pleadings of the
So
requisition.
you see, whatever be it, this is what has, and it appears to be fair to the court. I am only considering whether
fact,
to
my lord,
give them an interim
In fact,
protection
my lord,
today.
that is also
So-
not been pleaded in the repetition.
Whatever you take all this plea when you when the matter goes for final hearing.
This document, my lord, if I may say, my lord,
Huh.
the documents which they have said that it was not required for uploaded, my lord, it is a case, my lord, they have acquired this qualification after the cutoff date.
See,
That's the issue, my lord.
whatever it is, all that I am not disposing it
Yes.
of. You see, because at
Lordship-
page 130 also there is the
Yes,
before the
yes.
division bench also this issue has been taken. The cutoff date is only for such documents on the basis of which an applicant presses his eligibility, which are to be uploaded at the time of online filing of the application. Non-mentioning of the certificates of proficiency in Assamese so and so in the list of documents which are to be uploaded at the time of filing up of the forms makes the intendment very clear that it is only an additional qualification, and therefore such decreased qualification, even if required later than the cutoff date, is required to be accepted. So this was also the facts there, right?
That's the submission.
Correct, but based on those submissions which you are trying to also similarly say, the stay arrangement is
Single bench has decided that.
all right.
Anyway,
I am not differing from that. Heard Mr. NNB Chaudhary, Learned Counsel, appearing for the petitioner. Also heard Mr. B. Kaushik, Learned Counsel, appearing for
secondary education.
all the respondents.
Yes, all this.
For the Learned Standing Council, secondary education, right? For the state respondents. Huh? By way of this petition under Article 226 of the Constitution of India, the petitioners are selecting আর কি বুলি কলো? The petitioners are assailing the
It will 75, my lord.
huh?
That manner rejection is in 75.
Page 74 onwards.
74 onwards, 74 onwards.
Are assailing the rejection slips issued by the respective inspectors of schools to the petitioners during verification of documents, thereby debarring the petitioners from further consideration of the recruitment process in connection with the advertisement dated. Where do I find the date? Dated
20.
27/12/2023.
dated.
23.
Where is the reference of that? Dated 27/12/2023, issued by the Office of the Director of Secondary Education Assam, Kahilipara, Guwahati, /19, for recruitment, for appointment to the post of, for appointment of graduate teachers, inter alia, to the in the subjects of arts, science, and Hindi. I'm only saying that because for you it is only that.
Yes, my lord.
Inter alia. Stop. Mr. NNB Chaudhary, learned so-and-so submits that the candidature of the petitioners have been rejected in the verification process on the ground that while uploading the documents in PDF format at the time of submitting application, the certificate, this is a certificate, diploma.
Yes, sir,
The certificate issued by the Akhom Sahitya Sabha in connection with diploma
Diploma in Assamese.
in Assamese language were not uploaded. Stop. He further submits that under the terms and conditions of the advertisement, it is not mandatory to furnish this certificate while uploading the documents at the time of application. He further submits that it is nobody's case that the petitioners do not have the requisite qualification, and the petitioners could not upload the said certificate at the time of uploading their documents only because despite acquiring the said diploma, non-issuance of the said certificate by the issuing authority to the petitioners on that date, they could not upload the same. However, subsequently, the petitioners have been issued the said certificate, and the same are enclosed here,
Yes, my lord.
are enclosed to the writ petitions. Give me the enclosures as enclosed as annexure numbers, annexure so and so to so and so. I suppose they are there.
Yes, my lord.
Annexure 1 series.
Annexure 1 series. Stop. Issue notice to the respondents. Mr. So and so accepts notice on behalf of the respondents, extra copies within 3 days. heard the petitioner. Having heard the petitioner, till the disposal of this petition, the post equal to the number of the petitioners in all these in the instant writ petition shall be kept reserved, but the process of selection will continue. Stop. If the petitioner do not qualify in merit, then there would be no requirement of keeping such post reserved. Otherwise, the marks obtained by the petitioners in the final tally shall be kept. All these are required. The final tally shall be kept under a sealed cover, which shall be opened only after disposal of the petition. The recruitment process with respect to the other candidates shall be pursued and complete. When? After? Returnable 3 weeks. 3 weeks or a date?
My lord, may I fix a date?
Give me a date. 3 weeks or a date.
Any day
Revision is
after
fixed on 15.
15.
Any day after 15.
After 15 October, the date. List on such and such date. This is the order you wanted, isn't
Yes,
it?
yes.
So I gave the same order.
Yes. Certificate in page 31. madam. I just do.
Lordship, in this case, record was called for, record is received, Lordship. And as does it appearing in this case, Lordship. As does sending a higher division is appearing in this case, Lordship. He has some difficulties.
All right, another date then.
If
Heard. Actually, in this matter, I'm going to retire, my lord, by March of next year.
All right, we'll have it immediately.
What I
after
wanted,
the
I wanted to remand the matter to the governing body to consider my case. That's all.
but someone else is handling. So we can have it after the puja. You make that prayer on that date. Heard Mr. J. Abedin, learned counsel appearing for the petitioner. Also heard Mr. S. Bhuya, learned standing counsel for higher education, and Argohai for
Respondent number 7.
respondent number 7. Anybody else? A. Shumua for respondent number 3 UGC. Give your names, otherwise they'll all get confused. Mr.
as Bhuya.
S. Bhuya submits that though records has called for has been received. However, who is looking into?
As does.
Mr. S. Das is going to place it.
Lordship.
But you had appeared on the last occasion. But Mr. S. Das, who is the arguing counsel on behalf of the respondent, is having some personal difficulty today and accordingly seeks a short accommodation. Prayer is allowed, relist on such and such date after Jadidyak.
My lord, let it be on 15th, possible Wednesday.
Item number 3.
Yes, Mr. Das?
Matter pertains to selection of Anganwadi worker, Lordship.
Yes.
Lordship, on the last occasion, the court had directed the respondent number 4 to bring the service register, Lordship, whether the respondent number 5 falls under this jurisdiction of the Anganwadi work. That survey register we have not received yet, Lordship.
When?
Slight accommodation, Lordship.
So I'm asking when. You let me know. Heard Mr. H.K. Das. HR. I get confused with R and K all the time. Heard Mr. HR. No? HR Das, learned counsel appearing for the petitioner. Also heard MS Sharma. You, na? U Sharma, learned counsel appearing for respondent number 1 to 4. Ms. Sharma submits that the survey register as called earlier by this court is still awaited. Relist on such and such date.
After vacation, Lordship.
22nd.
Highly acknowledged.
Item number 6.
Please, your Lordship. Lordship, kindly may peruse the order dated 7/8/2025. On that day, they have submitted that the instruction has already been received. And on the last occasion also they took time.
But till they did not submit the affidavit in opposition.
Yes.
Today we are filing it, my lord.
You're filing it today?
Okay.
All right. Some more movement today.
My lord, it is a.
Anyway, they're filing it today.
The copy will be circulated to each
Uh,
of the day, my lord.
Mr.
H. Burwa.
H. Burwa, na?
My lord.
Learned Government Counsel,
No, my lord. On behalf of Mr. B. Gogoi, my lord.
Learned Counsel on behalf of Mr.
B. Gogoi, respondent
B.
number 7. B.
B. Gogoi, Learned Counsel, appearing on behalf of respondent number
7, my lord.
7, submits that the affidavit in opposition shall be filed within the course of the day. Relist next week.
A date may be given, my lord.
Pujar pisot on such and such date.
Oblige, my lord. Oblige, my lord.
Next week is the last week, no?
Yes.
Please, my lord. Lordship, in this case, lordship, we have received the instructions, my lord. Wait for some time to bring it on record. my lord.
All right. Your name?
B does, my lord.
Lordship on the loss occasion also.
He's already received it, so let him place it.
On the last occasion also, it was, it is responding to file there.
They were directed, but now they have the instructions. Mr.
B does, my lord.
B. Das, Learned Counsel so and so submits that he has received instructions in the matter and accordingly seeks a short accommodation to place the same by way of an affidavit. In view of relist after 2 weeks on a date to be fixed by the registry to enable the respondent to positively file the affidavit in opposition by the next date of listing. However, failing which the matter shall be proceeded in accordance with law.
Deeply obliged.
Deeply obliged, Lordship.
Yes.
May it please your lordship. The petitioner is.
Revision of fixed pay.
Yes, lordship.
Yes.
And on last 2 occasions, lordship, they have directed, respondent authorities has been directed to place whether.
Yes, Mr. Bora.
We have actually filed affidavit on behalf of respondent number 4. But here the stand of the government on behalf of the government political department is necessary.
Who is appearing for home and political?
I am appearing, so I
Then-
am seeking some time, your lordship. So that is not forthcoming, so let the matter be listed after vacation.
Last chance. No further time is going to give in to you. Mr. D. Bora Learned BORH, no? Bora Learned Government Counsel submits that the stand of the Home and Political Department, State of Assam, is essential for effective adjudication of the issue involved in the writ petition, and accordingly seeks a short accommodation to bring the to file the return on behalf of respondent number 1, 2, and 3. Prayer is allowed. Relist after 2 weeks on a date to be fixed by the registry.
Lordship, a date may be fixed.
Will come. Yes. Yes, Mr. Pathak.
Now the petitioners here, they are claiming the status of regular employees. They were initially appointed under Regulation 3F of the APSC regulation.
Why these regulation briefs are always so voluminous?
Lordship, because we need to establish that we were against sanction posts.
Don't take it so seriously.
Not, I mean, because
no, maybe because there are too many petitioners.
that also is a factor, Lordship.
How many petitioners in your?
119 of them.
119.
119.
Yes, now tell me, what is it?
Your Lordship, the
affidavits have been filed.
Affidavits have been filed.
So this pleadings are complete.
Pleadings are complete. In fact,
and the issue is regularization.
Not regularization. In fact, Your Lordship, there is a mandate under Article 320 that when
Article
320 that when appointment is made to any government under the state or the central government, any post under the state or the central government, there's a requirement for consultation with the union or the state public service commission. Now, Regulation 3F is an exception to that constitutional provision. In fact, the regulation itself says that the otherwise, except for those categories of cases, the consultation is mandatory. What has happened here in this case, Your Lordship, is that they were appointed against sanctioned vacant posts, but without undertaking the consultation, that is mandate of the constitution as well as the rules. They are now seeking to fill up the post through another selection process, the post which the petitioners are presently occupying. Now, without fulfilling their constitutional mandate, Your Lordship, they cannot proceed to now fill up the post through a regular process, which we are already occupying. That is the sum and substance of the matter. they have already issued the advertisement, and our extension of our service is till the 30th of this month.
Is there a stay?
In fact, your lordship, if your lordship has the order dated 6/12/2024, coordinate bench, when it was
Yes.
dealing with the matter, direction was passed that at the appropriate stage, the interim prayer would be considered.
You mean another bench?
Yes, another bench.
Yes.
There is a IA pending, which we have filed, because we have not challenged the advertisement. There are sufficient posts, your lordship, for them to continue with the selection process, because we have
But
not
this
challenged.
matter will need some
We'll need some hearing.
hearing.
In the meantime, your lordship, at least status quo, as because if your lordship has the
Mr. Chaudhary is going to object to that.
Yes, my lord, because the recruitment process, a new recruitment process has already gone through the stage of.
I am not
written
challenging that.
examination.
I am not challenging that.
But what about that approval? Have you taken that approval?
Lordship, here on the last occasion, AG was appearing today also it is coming, Lordship. Approval is not required, Lordship. Clear. They have been, it's a temporary in nature, their appointment. And
show me 3.
in the next case, Lordship, as and when the regular selection is required, Lordship, so approval is not required, and the government has taken a decision for to go for a regular selection.
Where are you showing from that approval is not required?
If I may take your lordship to 3F of the APSC regulations.
The Senator.
This is the APSC Limitation of Functions Regulations 1951. So under 320, if your
Wait,
lordship,
Mr. Pathak, I don't have the book.
Service manual. If I may take your lordship to Article 320 first, your lordship.
Your constitution. Doc. Yes.
Lordship will have Article 320, your lordship. There are 320 functions of public service commissions.
Three?
320.
Yes.
Yes. 321 says it shall be the duty of the union and the state public service commissions to conduct examinations for appointment to the services of the union and the services of the state respectively. 322 says it shall also be the duty of the union public service commission if requested by any two or more states to do or to assist those states in framing and operating schemes or joint recruitment for any services for which candidates possessing special qualifications are required. We are concerned with 3. The Union Public Service Commission or the State Public Service Commission, as the case may be, shall be consulted, A and B, on all matters relating to methods of recruitment to civil services and for civil posts, and B, on the principles to be followed in making appointments to civil services and posts, and in making promotions and transfers from one service to another, and on the suitability of candidates for such appointments, promotions, or transfers. And Lordship will have the
So you are trying to say that they have not consulted UPSC.
They have not consulted UPSC. In fact, your lordship will see the proviso at the bottom, provided that the president as respects the all India services.
You see, Mr. Pathak, what is your grievance?
My grievance.
Because now, if your as far as the advertisement is concerned, you see, because we are not going, this court is not going to interfere with the advertisement
Not at all.
at your instance.
In fact, we have not challenged it.
At your instance,
Yes,
correct?
Yes, your lordship.
Now, therefore, the issue that perhaps would arise in this writ petition, I have not even heard you and I have not even looked anything. But from what I could gather from your brief submission is that whether you are entitled to be regularized in the post that you are holding. Is that the issue?
No, your lordship. In fact, what we are
That
saying.
must be the issue.
No, what we are saying, your lordship, is
because they see if you're first of all, this court has to be focused with your right.
Yes, Your Lordship. If Your Lordship has,
As far as the government's decision to go ahead with the advertisement, that is the government's decision.
why?
This is not a PIL.
Absolutely.
So in order for you to challenge, you see, let's see your prayer.
Yes, Your Lord. Lordship will have our prayers at page number 39.
Yes. Directing to give the petitioner the status of a regular employee.
Why it has been worded so, Your Lordship, is?
But rightly, because this is what in your last 5 minutes I could also gather. Regularization is what you want.
Not
Now 2, prayer number 2.
Yes, Your Lord.
Appropriate order or direction to respond is not to bring the post held by the petitioners under the purview of any future recruitment. So in
Without
short, it is that.
Without considering the case of the
Yeah, so now whether that advertisement is issued under that aspect, perhaps this court is not going to go.
if I may
This,
place one thing, Your Lordship.
Now your appointment is to a sanction post, you are saying.
Yes,
And how many?
That is precisely. There are sufficient posts in the department that the advertisement can continue. There need not be any
But
order.
what right do you have for regularization?
Not for regularization. If Your Lordship has.
Was there any advertisement? How did you get it?
There was an advertisement. A selection process was held. Written tests were held. Interviews were held. Then a select list was published.
Are you saying you are irregular and not illegal?
Not at all. We are saying.
What are you saying? You have to be either one of them.
Why, Your Lordship? If Your Lordship has Rule 3F for once. Rule 3F. 3F, Your Lordship, the rule has two components. If Your Lordship has the principal Rule 3.
One sec.
Yes.
3F of?
The Assam Public Service Commission Limitation of Functions Regulation.
I think we are holding the same book. Just tell me the page number.
91, you know, in my book. So if Your Lordship have the proviso to the Article 320, there this mandate of consultation with the commission, appropriate commission, will be circumspect or subject to whatever regulations the state may frame. Now these regulations have been framed under that proviso. Now if Your Lordship has Rule 3,
yes,
the principal rule, it says, it shall not be necessary for the commission to be consulted in matters to methods of recruitment to civil services. Rule 3 is at page number 92, Your Lordship. If this is the same book.
3. No, it's not there. 3A. Assam Public Service.
Assam Public Service Commission Limitation of Functions Regulations 1951.
Yes.
Rule 3 starts at page number 92.
Yes, then it's A.
Yes, if I may read the principal portion of the rule.
Yes.
It says it shall not be necessary for the commission to be consulted in matters relating to methods of recruitment to civil services and post or the suitability of the candidates for such appointments in the following cases, namely. We are concerned with 3F. If Your Lordship has F at page number 95.
Yes. When
an appointment is to be made by direct recruitment to a temporary post created in a service, if it is necessary in the public interest, that the appointment should be made immediately and reference to the commission would cause undue delay. So that is one aspect. Then Your Lordship will have the proviso. Provided that if the post has been sanctioned for and is likely to last for more than 4 months, the commission shall, as soon as possible, be consulted in all matters mentioned in subclause 3 of Article 320. So in effect, this proviso goes back to the principal obligation of the state under Article 320. Here the records reveal the posts are sanctioned. There was a proper selection process.
Mr. Pathak, I am not inclined to give any interim protection to you. Can this matter be heard today or on another date? Because this matter is, we can hear proceedings are completed.
Just show one thing to Your Lordship for just my satisfaction.
Yes.
I have prepared a small chart, Your Lordship, which Your Lordship will have in the additional affidavit, which we have filed. It is at page number.
Both parties agreeable, I can take it up for final hearing right now. There is no difficulty.
Otherwise,
but if both parties are ready.
313. Page
313.
Starts at 313. Why I'm saying that even if some protection is granted, that may not affect them.
Protections, anyway, what you want to show? 315.
313, Your Lordship.
313.
Your lordship will see the paragraph number 4.
This
We have
is-
just
Yes.
made a calculation from the records available to us about the total strength in the cadre. So there are 449 total posts. 264 posts are occupied, which includes the posts which are filled up by the petitioner. And in fact, there are presently 185 vacant posts. So even if the advertisement is allowed to continue, but if the services of the petitioners, if they are not discharged, your lordship, because there are otherwise judicial precedents of the division bench of this court, which says that once you make an appointment under 3F, you cannot just discharge them.
Yes, Mr. Chaudhary.
These judgments are there.
Lordship, here there are judgment of this honorable court wherein it has.
No, I don't want to go into the merit of this.
No, but
Only thing I'm asking, are you agreeable to that proposal?
Lordship, 3Fs are not entitled for.
Are you agreeable to the proposal that
No,
because you have vacant posts?
Because it's a prerogative of the state.
No, under
Even
the,
if there is more vacancy, they may decide to go for a.
That's
limited
all right.
number.
I am not inclined to stay the advertisement. What I'm asking is that the advertisement is for how many posts?
195, Lordship.
And they are now these 264 posts are occupied by petitioner and similarly situated petitioners, right? So till disposal, don't touch them. You go ahead with your advertisement as
we have
planned for the
made-
post.
Lordship, we have made specific statement in the affidavit that the post the petitioners are holding that is included in the advertisement.
Is included.
Yes, Lordship.
All right. When can this matter be heard?
Lordship may take it since there are urgency on their part also because the
That
last
I'm
section-
asking when it can be taken up. You both give me a date today, right now.
I'm prepared.
Another date.
Lordship may take it up tomorrow on Monday.
Very well.
Next week is slightly tight, but immediately on the opening then.
But lordship, what I am apprehensive about is because discharge orders will follow immediately on the 30th. Now that will perhaps give rise to a fresh cause of action. So if your lordship will make any such discharge order subject to the outcome of this petition.
Where is the Advocate General?
Lordship, he is on legs in court number 5. Or Lordship may take it up at 2, Lordship.
Already two matters have been fixed for hearing only. Three
There-
matters. Three
In
matters.
fact, there is a division bench judgment of this honorable court. Can I?
Mr. Pathak, I'm not going to
No.
give you any interim in this matter. So there's no point.
That observation then is.
But I am ready to finally hear and put a logical conclusion to the matter.
Because
Lordship may, my suggestion, Lordship, may take it up in the second half. In the meantime, I'll try to.
All right. We'll have it at the second half. You see if
Yes.
the petitioners, because you see there are only how many?
119.
119. So if there cannot till then, you go ahead. They may not be affected.
In fact,
If that is agreeable, otherwise you come up with a date on which it can be.
lordship will have it on the second half.
This matter. Well, this matter pertains to non-payment of salary matter to an assistant teacher, that is the petitioner matter. Since the month of April 2018 matter, the petitioner has not received a salary.
April?
2018 matter. Last occasion matter, they had taken time to file their affidavit in opposition, but till date nothing has been filed.
Yes.
Please, your lordships, I'm appearing on behalf of R.B. Bora. In this matter, lordships, some up-to-date instruction is required. Some time may be given, lordship.
How many more times? Time and again, you've been taking time. This matter has been pending from the beginning of the year. Salary of the petitioner is stuck since 2018 April.
Lordship, on 12th.
You cannot be merrily asking time in such matters.
Lordship, 1 week time may be.
Monday, and if the instructions are not there, personal appearance of the concerned person. Yeah. A.
Iqbal.
Heard Mr. A. Iqbal, learned counsel appearing for the petitioner. Also heard MS. S. Boro, learned counsel appearing on behalf of MSRB Bora, learned counsel for the BTC. The issue involved in the instant writ petition is regarding non-payment of salary since the month of March 2000, March or April?
April 2000.
April 2018. Stop. It appears that the respondent, after issuance of notice on 17/2/2025, wherein the respondent, wherein the learned counsel for respondent numbers 3, 4, and 5 were present in court and has accepted notice, despite receiving of the notice, has been repeatedly taking time since then. It appears that on 7/4/2025, 3 weeks' time was granted to BTC for filing affidavit. Thereafter, on 28/7/2025, again, the respondents, more particularly BTC, was directed to file counter affidavit within 2 weeks explaining as to why the salary is not being paid to the petitioner. Today on call, once again, MS so-and-so reiterates her prayer for obtaining instruction as regards the up-to-date status of the as regards the salary of the petitioner. Stop. It appears that it appears that despite the seriousness of the issue involved in the writ petition, i.e. non-payment of salary since April 2018, the petitioner, the respondent BTC is merely taking time. Stop. Such casual approach of the respondent BTC is totally deprecated by this court. Be that as it may, by way of last opportunity, the counter affidavit as directed by this court on 28/7/2025, explaining as to why the salary of the petitioner has not been paid till date, shall be filed by the date of next week, so and so date, failing which the concerned respondent officer shall be personally present in the court.
Lordship, I am S.K. Pandey, appearing for the petitioner, Lordship. Lordship, on the last occasion, my learned... I'm sorry, Lordship.
Yes, Mr. Pandey.
Lordship, on the last occasion, my learned friend has stated before Lordship that he has filed some affidavit in the registry, but it was not before the Lordship. So Lordship directed to place the same on the record and extended the interim order. It was said that interim order shall continue. So Lordship, whether the affidavit is before the Lordship...
Yes,
Lordship, I filed the affidavit regarding maintainability of this petition before this. If Armed Force Tribunal has the jurisdiction.
This is the affidavit of 5/9.
Yes, Lordship.
Yes.
That Armed Force Tribunal is whether Armed Force Tribunal is functioning or not. Court has asked.
This is item number
11.
Is the officer in court?
Lordship.
Is the officer in court?
Yes, sir.
Yes.
Please take your seat.
Thank you.
Yes.
That's in terms of section 14 of the Armed Force Tribunal Act, Lordship, this petition is not maintainable here.
So you are questioning the maintainability of the writ petition?
The petition, he never said that the Armed Force Tribunal.
What is, Mr. Pandey, what is under challenge in the writ petition?
Lordship, in this case, we are challenging the proceeding of invalidating medical board, Lordship. Lordship,
Invalidating?
Medical board.
Medical board.
G. After conducting the invalidating medical board, respondents are trying to throw me out of the service, Lordship. That is under the challenge. Saying that I'm quietly well healthy, and as per Rule 15(2), the IMB can only be conducted if the individual is incapable of performing duties, Lordship, which is not the case here. And that is why the interim orders were granted in my favor, Lordship. And moreover, Lordship, I may submit that on 18th July.
Mr. Pandey, I'm sorry, but I'm not being able to follow anything that you have said, except the word medical board or something.
Invalidating medical board, Lordship. It is called in short IMB, Lordship. This invalidating, after this conducting invalidating medical board, Lordship, they can send me out of the service, Lordship, if they want, Lordship. That is under the challenge. I believe Lordship has understood my submission.
Yes, what is the ground of maintainability?
Lordship, there's Armed Force Tribunal.
Yes, I have it.
Armed Force Section 14, Lordship, the jurisdiction powers is. But at the first instance, he has to move before the.
Which section?
14, Lordship.
Have they replied to it?
No. It was moved in the vacation court, Lordship. I was just given the notice on that day, Lordship, that on that day I cannot challenge the maintainability of the petition. After going through that, Lordship, I've
Yes, please read.
Section 14, Lordship,
yes.
Jurisdiction, power and authority of the tribunal. Jurisdiction, power and authority in service matters. He is Armed Force, Lordship.
Yes.
Save as otherwise expressly provided in this act, the tribunal shall exercise on and from the appointed day all the jurisdiction, power and authority excessive immediately before the day by all court, except Supreme Court and the High Court, exercising to 26 and to 27 of the Constitution in relation to all service matters.
So this is a service matter?
Yes, sir.
Yes. What do you have to say to that?
Yes,
This
Lordship.
petition is not maintainable because there is a defecation alternative remedy.
Yes,
Section
Lordship.
14.
I'm coming to that, Lordship. I'm coming to that.
Yes.
First of all, my submission is when the matter was taken on 18th July, and the Lordship has pleased to issue notice to respondent, there was no preliminary objection was taken, Lordship.
Noted.
Yes, sir. Then the matter was taken on 22nd August. Then the Lordship directed the UGC is to certify that Armed Force Tribunal is functioning in Guwahati by way of affidavit by enclosing appropriate order notification regarding the constitution of Armed Force Tribunal. This order has not been complied as the content of the affidavit says, Lordship.
Annex, Lordship, in the affidavit, Lordship, I have annexed the notice issued by
Where is it?
Page 190, Lordship.
Page
190. This is the notice of the register. I see that AFT is functioning. His contention was that the AFT is not functioning in Guwahati. This is the 18th.
But this affidavit is filed by whom?
Lordship, the Commandant, Lordship.
Filed by the armed forces.
Lordship.
But the direction of this court was to whom?
It was to the respondent.
To the respondent.
Sorry, Lordship. Sorry, it is to learned UCG to certify that Armed Force Tribunal is functioning in Guwahati by way of affidavit by endorsing.
Learned CGC.
Lordship.
So you are a CGC.
Lordship.
Is to certify that the Armed Forces Tribunal is functioning in Guwahati by way of. How will you certify?
But I have annexed the notice of that the tribunal is functioning, Lordship. This was 12th August 25 notice, Lordship.
All right. Anything more?
No, yes, Lordship.
Yes,
now,
please.
Now
please,
before,
I'm hearing you.
Yeah, Lordship, I'm obliged, Lordship. Lordship, now coming to affidavit, Lordship.
Yes.
Now, this affidavit has been sworn by as the copy has given to me, it has
Yes.
been sworn by the AOC, that is
Yes.
Air Force Station Kamrup. Now, this AOC is not a party to the present writ petition, Lordship.
Okay.
So therefore, he cannot file affidavit on behalf of all the 6 respondent, Lordship. At the most, he can file affidavit only for the respondent number 1. This is first issue, Lordship. Then the Lordship, so far coming to the functioning of AFT Guwahati, Lordship, this tribunal, though there is a office in the AFT Guwahati, but presently this AFT is not functioning because of the want of the quorum. Honorable judicial member is not
Mr.
available.
Roy, you see, there is no difficulty for me to dispose it today, but the
Ji.
thing is that since such a contention is being put on oath,
Ji.
right, that
Ji.
presently it is not there. Why don't you get a proper clarification and why?
I will file the reply, Lordship. I will file.
He has not yet filed any reply in the writ petition. He has not stated that the AFT is-
Mr. Pandey, are you filing any reply to the affidavit file? Because I was taking up the matter to dispose it off.
Lordship,
Do you want to file any reply or should
yes,
I
Lordship.
take it up for final?
Yes, Lordship. I will file the reply and I will
As
prove
prayed
that.
for by Mr. So-and-so Pandey, Learned Counsel, appearing for the writ petitioner, relist after 2 weeks, A.M. Pandey. Senior
Lordship, I'm
counsel,
sorry.
assisted by Mr.
S.K. Pandey. Lordship, I'm S.K. Pandey. Last time it was wrongly written as A.M. Pandey. I'm S.K.
That's why I was
Yes,
referring
Lord.
you as AM.
Ji.
S.K. Pandey, Learned Senior Counsel.
No, Lord. I'm sorry. I'm not a senior designated counsel.
Everything is wrongly recorded in the last order.
Last, it was clerical mistake.
This happens when you appear
Ji.
virtual.
Ji.
Yes.
Lordship, I'm S.K. Pandey and I'm an advocate. My
All right.
there.
Heard
Yes,
Mr. S.K. Pandey, Learned Counsel, appearing for the petitioner. Also heard Mr. So-and-so, S.S. Roy, so-and-so. Mr. S.S. Roy, by filing an affidavit in opposition, has clarified that presently there is no Armed Forces Tribunal functioning. Functioning.
Yes.
Sorry, is functioning. Sorry, Armed Forces is functioning. However, Mr. So-and-so objects to the same and seeks a short accommodation to file a reply affidavit. Prayer is allowed. Relist after 2 weeks on a date to be fixed by the registry. Interim remedy shall continue till the next date of listing.
Obliged, Lordship.
And
I'm
Mr.
obliged.
Roy, why don't you file an affidavit indicating what is the present status there? I'm sure there must be a website. Everything will be there. Why don't you put it on record by your affidavit? At least because there's a judicial order which says learned CGC
Lordship,
certified.
that's why I have
So you
annexed
put that certificate.
I have annexed the notice and address.
You see, but you have not certified it.
Lordship, it
But
was
there is a judicial order, so you
Lordship,
see how
it was,
to do it.
Lordship, it was certified by me, Lordship. That
No,
but
that
the
is different.
that
That is
affidavit-
different. That is what you do when
Lordship. Understand?
because of the judicial order.
Lordship.
Because you see,
Lordship,
I'm sure everything is there in website. You just get hold of all that.
Lordship.
Yes,
Lordship,
next.
even the government of India.
All
has
right,
issued
your matter. I have passed the order. Yes, next matter.
Yes, Lord. Obliged, Lordship.
May I please, Your Lord?
Yes.
Lordship, in this case, the petitioner appeared for the final exams of HS. Now, in her result, though she participated in the practical examination, her practical marks was not uploaded by the college authorities, and due to which she was marked absent in the final result, against which she made the representation. The college authorities also reproached the controller of exams, admitting their this error on their part in uploading the marks. Now, in spite of that, the stand of the ethics board is that there is a standard operational procedure in place which prevents them from rectifying. Now, my submission before your lordship, I'll take the relevant documents. My submission is a student's career is at stake, and due not to any fault of hers, her marks which she had obtained, she obtained 18 marks in the practical, which was not uploaded in the system. She is being erroneously marked as absent.
Marked as
absent.
absent.
Yes. And because of which his final result is shown as
Absent in that
practical.
exam, practical
yes.
exam, because her mark was not uploaded.
Okay.
And this is an admitted fact.
It is an admitted by the college authority, and they had even written to the controller of exams. Now, controller of exams, etc., their stand is that there is an SOP in place which prevents them from doing it. My contention
Doing
is
what?
They have brought on record. I'll take your lordship.
No, but you see, if that is an issue, this is extremely unacceptable to a writ court. As why should this the student suffer for no fault of hers?
That is the only thing, your lordship. I will take your
Who
lordship first.
upload the mark?
They have admitted, even they
No,
wrote
Mr. Viswas, who will upload the mark?
the college authority.
College authority.
And the
where,
respondent.
and where is that part admitted?
Yes, your lordship. Annexure G, your lordship.
Page
34. First of all, your lordship may kindly come to page 32, is the annexure E, the mark sheet.
Yes.
At history, in the practical, your lordship will see ABS, that is
Yes.
absent.
History.
Theory, she got
Why do you say practical? Oh, here, PR. PR. So this is shown as absent.
Absent. Now I'll take your lordship to page 34, annexure G, your lordship. Annexure G, this is the college authority written to the controller of exams.
Who is for the college authority? Mr. Chutia, you are? No, Mr. Datta. Mr. Chutia is for whom?
I am for a board, my lord.
For the board. The hurdle is by who's giving you the hurdle? Mr. Chutia or Mr. Datta? Mr. Chutia. That's why he is standing in the. All right, yes.
Now your lordship will see, if I may read out, your lordship.
Yes.
This is the principal of the respondent number 3, Kachar College. With due respect, I would like to bring your attention that the project assessment mark of one of the student of Kachar College who appeared in the final examination have been recorded as absent. However, the student had duly appeared in the project and submitted their respective project within the stipulated time. All relevant supporting documents are enclosed for your reference. Kindly look into the matter and arrange for the necessary correction by entering the appropriate project assessment mark for the concerned authority. And in support of that, annexure of this 35 is the mark 18 marks. History. It is signed by the internal examiner as well as the principal. Then the next page 36. The third column is the petitioner's. Her attendance is shown, your lordship, page 36. It is an extract given by the principal. Third column, 3 roll numbers, third roll number.
Yes.
History, second column. She is shown to be present. And
Yes.
then the last at page 37, the second, she is
Yes.
from the bottom, the second from the bottom.
So here it was history, no? That mark was otherwise?
Yes.
History, yes.
So
this is shown as and no, page 36 is what? An attendance?
third column.
No, 36 page 36 is the attendance sheet.
Attendance sheet, which she appeared.
So this shows
She was on the, it was held on 1st of February. So she's attendance, her sign is there, and it is
where's her sign? Signature.
The signature of the candidate with date.
Okay. What is pose, history, subjects?
Subjects. Economic is there.
Okay. Then page 37.
Political science, that is there. And then page 37 is the from bottom, the second.
Yes, I have seen 18.
18.
Yes.
Now, she also personally wrote 2 letters to the controller of exams.
Yes, I have seen.
H.
Yes.
H is there.
Yes.
And annexure F was also there, page 33. She was immediately when the result was published.
Okay, Mr. Viswa.
Yes.
Mr. Chutia, why? Because it appears that she has actually appeared. It is the
Actually, we
because
don't
of
know, my lord. Not
no, but these documents are showing.
document, my lord. I will show you page 36, lord, kindly.
You are doubting these documents?
Yes, definitely, my lord. If they otherwise, my lord, those who are not appearing in the examination, they have been allowed to pass.
So why those who are taking pain, they write, they passing the exam, sit the examination, pass the examination, what is the difference between?
Sorry?
Suppose the students are appearing in the examination having pain day and
Having?
night, having pain day and night, they study, they are appearing in the examination. And I think as per our record,
Why are you getting so
they are not
personal in
appearing.
this matter?
They are not appearing, and if
Mr. Chutia, you see, we don't know the facts. Neither you know nor I know, correct? We go by records.
records,
Right. Now the record, I am only asking you
but
why.
not why it's 36
Yes.
to quality.
Yes. Yes.
These are the marks rule. My lord, Lordship Policy bottom
Yes.
signature of internal examiner
Hmm.
and 1st of February 2025.
Hmm.
Lordship internal examination, Lordship knows it. Suppose I am the external examiner and Mr. Biswas is the internal examiner of the department. Who will give marks? External marks. No internal examiner can give marks because he is a student. How he can give a mark? There is Lordship College signatures, bondita, normal something is malad. I cannot read it. So bondita something is shown as the internal examiner. The Lordship College see our affidavit, page 47.
In this context, just
One sec, Mr.
Let me complete, then you should.
These facts are not narrated in the affidavit. That is what I.
Mr. Chutia, I am still.
That was, my lord, I was
One
supposed-
second, why are you both getting so agitated? Don't get so anxious, not in this court. I am only trying to understand.
Yes, yes.
Mr. Chutia, page 36, please explain me what you want to point out from here. I'm sorry, I'm not being able to
Oh, yes.
appreciate it.
36 Lordship College see.
It's a signature is of one external examiner.
Examiner.
With date.
Internal examiner with day.
No, external it says.
Yes, not external, but external signature is not there.
No, this signature is there, no?
No, only internal.
Why are you saying internal?
Yeah, internal examiner cannot give marks.
Where is the mark?
Mr. Chutia,
This
page
is the
30.
attendance sheet.
Mr. Bishwas, please stop the running commentary.
It is a marks for page 36.
No, it is the attendance sheet. Look at the top.
No, my lord, Kasar College
Look at the top.
marks foil.
No, page 36. I think you are holding a different document.
38.
36.
I am not talking about a 38. I am talking
30?
about the 36.
There is an error in his thing, I think, in the page. That is
No, let me finish.
Mr. Chutia, which document are you placing?
36.
Page 36 in the code file is the attendance sheet.
Here is Pala 36 is marks foil, Lordship College.
So that is why you see I'm not being able to understand what you are saying. You are also fuming for some reason. I don't know why.
That is they are submitting, they are providing us copy.
It's okay. I think you're in. You
Page
want to
38
relax.
is the one.
You are page 30.
8.
Now, in his page,
No.
no, not your lordship.
Oh,
Apna 36.
that's wrong, my lord. He has
Achha, now you want that marks foil.
marks foil.
Marks foil.
Or Lordship College is marks foil.
Yes, signature of internal examiner.
Examiner.
He has signed, but no external examiner
Yes.
signature.
If it is the exact copy of the ballot marks foil.
No, but then this also applies to all these other students. Alia Hassan,
Yes.
Alpana Sinha. This is not only to the petitioner. Now these people too, they must have passed. Their results must be out.
I don't know, but I will have to verify
So
whether they
I'm sure you verify that because you have given it, then you can't raise this. In your affidavit, where are your grounds?
That's why I want to one more time, my lord.
No, let me see your affidavit. Where is your affidavit?
To additional affidavit in this regard, my lord.
Where is your affidavit? Have you filed affidavit?
Yes.
Your respondent 2 and 4.
Yes, my lord.
2 and 4.
2 and 4.
Yes.
Lordship, see our affidavit, my lord.
Let's see your affidavit.
Page 44.
Yes.
And relevant portion, Lordship, kindly see page 45. These are the SOPs, guidelines for practical and
Let us see your SOP.
repeat, my lord. Contention.
Yes.
Paragraph, Lordship, 4. The
Yes.
best to say that page 41, my lord, running page. begs to state that the guidelines for practical and project examinations of higher secondary final examination 2025 was issued by the deponent by notification dated 16/12/2024. In the said notification, SOP for the conduct of practical and project examination 2025 has been included. Clause 10 of the SOP has clearly stated that head of the institution and internal examiner will jointly enter the separate marks into the online portal. Before entering the marks into the portal, head of the institution and internal examiner both will cross-verify and roll number and marks number carefully. Marks once submitted in the portal cannot be edited. Printed marks foil will have to be uploaded in the portal duly signed by the internal examiner and external examiner and head of the institution, 3 persons, for completing the process. Moreover, in the clause 11 of the SOP, it is also stated that there will be no separate online portal to mark attendance in practical or project examinations. Head of the institution and internal examiner will remark the candidates as absent in the mark entry portal for absentee students. Once submitted, there will be no scope for editing so and so. And paragraph 5. The deponent begs to state that the authority college, Silchar College, by following the SOP issued under notification dated 16/12/2024, has uploaded the marks foil of practical examination duly signed by the internal examiner, external examiner, and head of the institution in the online portal of board on 10 February 2025. In the marks foil uploaded by the authority of Kasar College, Silchar against the petitioner rule number so and so number 78 shown as absent. As the result of the petitioner declared failed due to absence of the practical examination of the history, she is the eligible for appearing the comparable examination for the subject history. Here is, my lord, the petitioner career is not totally stopped. Suppose as per both she has failed, so she is given a liberty to appear in the comparable examination in the particular subject. There is no stoppage. So, Lordship kindly see page 44 and 45. These are the guidelines. Serial number 10, Lordship kindly see. The head of the institution and internal examiner will jointly enter the sequence marks into the online portal. Before entering the marks into the portal, head of the institution, internal examiner both will cross-verify and rule number and number-wise mark carefully. Please note, marks once submitted in the portal cannot be edited. Printed marks foil will have to be uploaded in the portal duly signed by internal examiner, number 2, external examiner, and number 3, head of the institution. There will be no separate online portal to mark attendance and practical examination. Head the institution and internal examiner will mark the candidates as absent in the mark entry portal for absentee students. Once submitted, there will be no scope for editing the present. So, Lordship kindly see page.
These are guidelines, no?
Guidelines. The how they will upload their results in the portal of the board. So, kindly see page 47. This is uploaded. They have uploaded this page 47. And 48 is the petitioner's name, serial number 78. Page 48.
Page 47 and then
this is the result sheet, mark sheet.
Yes.
Uploaded by the college.
Yes.
And this is serial number 78, rule number so and so, number 10178, absent. So, this is a Lordship kindly see. So, in the bottom, my lord, the marks submitted in the portal will be considered for result calculation. Uploaded the verified and signed printed mark foil in the practical marks entirely portal for completing the process of the mark entry. I certify that information provided above is authenticate. I shall remain responsible if it is found to be false and misleading.
Who is this person who has signed it?
These are 3 persons. One
Who are
is
these 3 persons?
3 persons. Anupurna
who's representing them?
I don't know, they are not backing party.
No, they are under whom? Mr. Datta's client? College, no, Mr. Datta?
Yes, from the college.
So what actions have you taken against these 3 persons?
In fact, your lordship will see that where is the error.
The absent
The student did not commit any error in this case.
Mr. Datta, I'm not on the student right now. I am on the institution.
Exactly.
You are representing the institution? Because it appears that the institution, this document, she has been marked absent, correct? Now, it appears that that is an error.
There is an error.
Now, what have you done?
That may not, so far.
What have you done?
They have taken any action or not, that I.
That is what is important.
Yes.
That is what is important.
Yes, that I'll have to take the instruction.
You get that instruction?
If they haven't done anything, they'll have to.
No, they have to be done.
Yes, definitely.
That cannot be any way out. This you must address. In fact, your affidavit should have contained that, because it appears. Then that affidavit should have indicated what actions has been taken against these three persons. Because whether now what benefit can be given to the petitioner is another aspect.
Yes, madam.
Because these are serious issues. Today, one could be a genuine case. There could be also instances which may not be genuine. That cannot be ruled out. These are important issues. That is why these guidelines have been framed, where they have said that once this has been done, then there should be no change. And therefore, they say that whoever uploads, they will take utmost care and responsibility. This is what the format is also.
They haven't done intentionally, my lord, that they will have to be taken.
Then why that affidavit has not come? By now I'm sure by now the college ought to have taken that action.
I don't know whether any action has been.
No, it should have been. When was this error done? And this date is
10th February 2020.
February, alone.
we are in September.
Yes.
You don't need a liberty from this court to take these.
I'm not at all.
Yes, you see, Mr. Datta, because it definitely looks like because of this error, somebody is now being very seriously prejudiced. All right, compartmental examination, but that doesn't take care, because it may be a genuine mistake. Now we don't know about it.
Yes.
We don't know. It is appearing to be genuine to this court because
The college.
there is nothing else.
Monday, my lord, I'll take the
You
instruction.
have the instruction. What has happened?
Yes.
Monday. Heard Mr. A. Biswas, learned counsel appearing for the petitioner. Also heard Mr. T. Chutia, learned counsel appearing for.
Respond number 2 and 4.
You are appearing as additional senior government counsel.
No, as a separate standing counsel.
Standing counsel, secondary.
No, my lord, Assam State School Education Board, SF.
Huh? And Mr. S. Datta, learned senior counsel, assisted by MSK Bora for respondent numbers
3, alone.
respondent number 3 and Mr. S. Bhuya for 1 and 5. It appears that the issue involved in this writ petition is the grievance canvassed on behalf of the writ petitioner is that because the petitioner has been marked absent inadvertently by the internal external examiner external examiner and the respondent and the head of the institution of the respondent number 3.
Yes.
Despite the petitioner had appeared in the practical test examination for the subject history on
First of February.
1st of February 2020.
on 1/2/25 and having also secured 18 marks
Yes.
is now she has failed, huh?
She has
She has
been
failed.
failed here because of the.
She has been shown fail. Stop. On a pointed query to Mr. Soen Datta, learned senior counsel appearing for the respondent
Number 3. Your
Number 3, as what actions has been taken against the 3, no, tar agot koba. Your affidavit is there, na? You have not filed. No, 1 second. It further appears that, where is that letter of the college?
college annexure G, Your Lordship.
Which page? It further appears that
Page 34.
that the principal of the Kachar College, Silchar, has admitted the aforesaid facts and has written to the Controller of Examination, ASSAB, requesting to look into the matter and correct the assessment marks for the petitioner. Upon a pointed query being posed, upon a pointed query being put to learned Mr. So-and-so, learned senior counsel, appearing for the respondent number 3, as what actions have been taken against the internal examiner, external examiner, and the head of the institution who has uploaded the. This is upload, na?
Results, marks, practical
Is
marks.
it uploaded or who has entered?
Uploaded marks, man.
Who has
Uploaded marks.
entered the marks in the
Portal.
final examination in the practical attendance sheet of the final examination and uploaded the same in the portal, na?
Yes, man.
In the portal concerned. Comma, he seeks a short accommodation to apprise the same. Stop. Relist on such and such date.
There is an interim, Your Lordship.
Interim, if any, shall continue till the next date of listing.
Highly obliged.
Much obliged.
6.
Lordship heard this matter on the other day, Lordship. It relates to the
Stuffing
non-release of
pattern,
the.
Lordship, is not yet finalized, Lordship. The stuffing pattern, as per verbal instruction from the office of the ADC, Lordship. And the board in its affidavit, Lordship, has stated that no upgradation salaries would be paid until finalization of the stuffing pattern.
One second. Where is that affidavit? Paragraph 5.
Paragraph 5, Lordship.
It is still not done.
Stuffing pattern is not yet finalized, Lordship.
So by when can it be done? What is your instruction?
Lordship, my instruction is that there was an order of this honorable court, Lordship. Ekon dibosun dada.
Yes, Ms. Sharma?
Whereby, Lordship, the financial powers was
I
restored.
cannot read this. It's
a bit ineligible, Lordship.
the highlighted portion.
Highlighted portion,
Yes,
Lordship.
yes.
In view of the above, the financial powers of the Borpeta Road Municipal Board stands restored. However, the board shall exercise their powers strictly in accordance with the financial rules and model code of conduct which is in force presently. Therefore, Lordship, I am of the instruction they have given me is that within 6 months of that period, the financial power were restored to the municipal board.
And it is not with the ADC to deal with any financial transactions, Lordship.
So who has to do it?
The chairman, Lordship.
Chairman of?
Borpeta Road Municipal.
Who is
Board.
appearing for them?
Miss Madhuchandra Bhattacharjee.
Where is she?
Additional senior.
She's not here. Monday? Monday বহুত বহিছ হৈ গৈছে নেকি? কেতিয়া ৰাখিবা? Then get hold of her
Lordship.
at 2. Let us see. I'm not doing it. Let us see. Let us have her, because then she might have to obtain some instruction.
He said that she has also not received instructions.
So no, then we can ask her to obtain that specific instruction. Otherwise, I see there is no problem for me to adjourn this matter to the next after post puja. But then that will not do any good to the petitioner. He's suffering,
Yes, sir.
isn't it? So you get hold of if you in fact oh, it's already 1.
No.
So after
Lordship.
at 2, maybe you call their matter first, because the rest matters that I have fixed are for mostly for delivery of judgments only. So first theorem mati dibo. Your matter, so you have Miss Madhuchanda. Huh? Mati diok. Atta bajis. Aru ase ni?
Orders.
Oh. Atta bajis.
Yeah.
Diok. Atta diok.
Order item number 3914.
Yes, Mr. Chaudhary.
My lord, this matter was heard and it was reserved for order, then my lord, again it has been released. The fact of the matter is, my lord, the writ petitioner without any order is functioning as a principal. Initially, my lord, my appointment, my selection was not approved.
Why is this come for orders?
No, later it was listed, they took time on last occasion, my
So
lord.
it has to be fixed for hearing.
Well, there is some urgency in the matter.
So have it on a hearing date. Have it after the puja then.
My lord, will it be inconvenient to have it on Tuesday, my lord?
Hello, Mr. Chaudhary. Next week, I have been warned by my court master not to go ahead, because I was going ahead and posting all matters next week. He says that we've already posted a lot. I can try. I can try, but
My lord, the earlier this matter was hot for 2 days and thereafter.
yes, it appears that by another bench. I have seen all that.
Prepare a detailed hearing. And in fact, there is no detailed hearing, my lord. Is a very
Anyway,
short point. On same
Tuesday.
Go on filing the petition.
This matter has been wrongly listed today in the order column. Relist on Tuesday in the. It has to be in the hearing
For
column.
admission.
This is in the admission column as first item on Tuesday.
Deep level.
First item in the admission column.
So the interim order earlier.
Interim order, if any, shall continue till the next date of listing.
Your Lordship, due to some personal emergency, I won't be able to do the matter. Item number 32.
All right. Item 32, as prayed for by MS B.
Swati B. Barwa.
Swati B. Barwa, Learned Counsel appearing for the petitioner, relist after 2 weeks on a date to be fixed by the registry. Yes.
Deeply obliged.
26.
Lordship. May I please, Lordship? Lordship, in this matter, I had a talk with the chairman of the municipal board, Lordship. So they are looking into the matter. So they just conveyed me to obtain some time, Lordship. So
All right.
that
Heard Mr. MP Sharma, Learned Counsel appearing for the petitioner. Also heard MS M. Bhattacharjee, Learned Counsel appearing for the respondent numbers 3 and 4, and MS U. Sharma, Learned Government Advocate appearing for the respondent numbers 1, 2, and 5. MS U. Sharma, Learned Counsel for the Learned Government Council, submits on instruction that, yes, what was that instruction? That the financial submits on instruction that the financial powers of the Borpeta Board Municipal, Borpeta Road Municipal Board stands restored. However, the board shall exercise their powers strictly in accordance with the financial rules and model code of conduct, which are as applicable, as applicable. This was your submission, right? You can't read this document, very difficult. MS so and so seeks a short accommodation to a price to obtain specific instruction in this regard and place the same by the next date of listing. Yes, when? After relist on such and such date.
Lordship, will they kindly be-
I said such and such date.
I know that, Lordship.
So
If your
you
Lordship is-
just get it. Yes, a
it be
lot of
taken as-
matters are there. You suggest and get a date.
Can it
Yes.
be taken as part heard, Lordship?
No. Mr. Counsel, please don't unnecessarily waste judicial time. Yes.
Time being item number 34.
No, read matter to good. No, there was one matter which was fixed at 2 o'clock. Where is that matter? No, there is another one.
Item 9 was also fixed at 2 o'clock.
No, not that. There's one matter which actually I said will be the first and then. Where that Lot Mondal case, where
Item 37.
37? Mr. Saikya, you are in that
3F matter case.
3F matter, Mr. Pathak's matter. It seems that 3 matters have got fixed at 2. So I did told Mr. Pathak and Mr. Chaudhary that first I will take up those matters because or judgments are going to be dictated in court. At least in one. I have forgotten Mr. Chaudhary and Mr. Deka's matter, but the other one I remember. So I'll just complete that.
No difficulty.
And the only thing is that he was insisting for an interim, which I said that I'm not inclined to give any interim protections, but I'm ready to take up the matters for final disposal. Of course, today there will be no time. So if you all have a consent date, then you can suggest we can have it fixed.
Tuesday.
Mr. Saikya, Tuesday already, it seems that all the matters today are of high urgency.
20th.
I can keep fixing matters. No,
25th.
it's only if time permits.
25th.
25th?
Thursday.
Okay.
Deeply
So, item, Mr. Pathak, item number?
9.
Item number 9 hot diba, D Saikya ichi respondent pala, D diba, B Saikya aru P Pathak for the petitioner, huh? As prayed for curricula. Okay.
Highly.
Just give your appearances, your names will come.
Item 37.
तो cause listed at 2 बिली देखवा ना नहीं तो मैं माता नस्ला जा ओ अच्छा Mr. Chaudhary, your matter is yet to be heard, isn't it? Yes. This I have actually completed the hearing on the other day and we fixed it today only for dictating the judgment. So before I forget, let me just quickly try and give that judgment. Huh?
One instruction.
One instruction. This is by you. This is by you, right? Compilation. Take your seats. Heard Mr. B.K. Das, learned counsel appearing for the petitioner. Also heard Mr. M.S.M. Bhattacharjee, learned additional senior government advocate appearing for the state respondents, and Mr. S. Das or Doctor? Doctor. I think by mistake your name appeared Das in the last order. Sorry for that. As Doctor, learned standing counsel for the revenue department. Stop. By way of this petition under Article 226 of the Constitution of India, the petitioner is challenging the impugned order dated 14/10/2024 passed by the District Commissioner Borpeta, placing the petitioner under suspension and the subsequent extension orders passed thereof. The brief facts of the case is that petitioner was working as what? Lot model, na? Huh? Petitioner?
Earlier it was called lot mandal, now it is.
No, I'm talking about the earlier.
Lot.
The brief facts no? Let me, the factual metrics. Is that the petitioner who was working, the petitioner while was working as lot mondal in the
It is establishment of
that paragraph. You just indicate the paragraph. I'm not being able to where all these details are.
Para number 3 is there.
Para number 3.
Yes, the petitioner confirmed the establishment of deputy commissioner.
In the establishment of Deputy Commissioner Borpeta was placed under suspension on account of his arrest in connection with a criminal case alleging demand and acceptance of illegal gratification.
Not for arrest, my lord. That is not in connection with arrest. That is on basis of a, my lord, complaint that is lodged.
All right, sit down. Suspension was placed under suspension by order dated 9/10/2024. Thereafter, the petitioner was released on bail on 30/10/2024. Which was intimated by the petitioner on 10/12/2024 to the office of the respondent number 1, 2, and 3. To the office of the respondent numbers 1, 2, and 3. Thereafter, where is the show cause notice? The charge sheet page 40.
Is 96 of my
Affidavit in opposition.
What is the date? Thereafter, the charge sheet
1812.
was served upon the petitioner on 18/12/2024, i.e., within the stipulated 90 days period from the date of suspension. Thereafter, the petitioner's suspension was further reviewed and extended by order dated 22/1/2025. Stop. It is the specific case of the petitioner that the aforesaid review and extension of the impugned suspension was after the lapse of the 90 days time period, stipulated 90 days time period of the suspension, and hence the impugned extension is of and hence the continuation of suspension beyond the expiry of the 90 days 90 days period makes the suspension order bad. Makes the suspension ineffective. Ineffective. Stop. Mr. So-and-so, learned counsel appearing for the petitioner submits that the law laid down by the apex court in Ajay Kumar Chaudhary versus Union of India, reported in 2015, volume 7 SSC at page 291, mandates that the suspension order must either be revoked or extended by a reasoned order within the period of 90 days, comma, failing which the suspension automatically lapses. According to him, review beyond 90 days renders the order unsustainable. Stop. In support of the aforesaid, he relies upon the following decisions. Number 1, 2010 volume 2 SSC 222 এইবোৰ তুমি এই লিষ্টখনৰ পৰা দি দিবা হা. Number 3 ইয়াতে আছে Rekibuddin Ahmed. Number 4 WA 114/2020 এটা ফুল গোটেইটো লিখি দিবা হা. Ajay Sonowal. Number 5, number 6 ইয়াতে আছে এইটা লাষ্টৰ লৈকে বুলবুল চৌধুৰী গোটেই the Mr. So-and-so Mr. So-and-so আগত লেখা MS So-and-so learned MS Bhattacharjee learned So-and-so on the other hand submits that the charge sheet admittedly having been served during the currency of the 90 days time period and the same having been extended thereafter upon the 90 days time period having expired by a reasoned order, the mandate of Ajay Chaudhary Supra is sufficiently is fulfilled and the is fulfilled. Stop. She relies upon the decision of the coordinate bench of this court in the case of Samsul Haq so-and-so in WPC 4107/2024. Mr. S so-and-so submits that pursuant to the direction given by this court in terms of the decision of the apex court, in terms of the direction of the apex court in Ajay Kumar Chaudhary Supra, comma, the respondent has issued office memorandum dated 4. Yes, what is that office memorandum? 4 to so and so. Prescribing timelines for review of suspension. The said memorandum provides that where a charge sheet is served within the currency of 90 days, comma, the review of suspension may be conducted within 6 months thereafter. In the present case, as the charge sheet was served within 90 days, the review conducted within 6 months is strictly in accordance with the said office memorandum. He further submits that though the learned counsel appearing on behalf of the petitioner challenges the competence of the reviewing authority, however, the same is unfounded, inasmuch as the office memorandum empowers senior secretaries to delegate such authority to heads of departments, comma, and in any event, the review undertaken by director, comma, land records and surveys, correct, was in accordance with departmental authorization. In support of the aforesaid, he submits an instruction dated 18, and he submits, this is an instruction to you, submits an instruction, he submits the instruction dated 18/9/2025, received by him from the office of the Deputy Secretary to the Government of Assam, Revenue and DM, pursuant to this court's last order dated so and so, wherein the director of land records and surveys, etc., Assam, is said to be the concerned appointing authority. Stop, huh? The document, the instruction dated so and so, along with the enclosed notification dated 3/11/2023, is kept on record and marked as A. Stop. Heard the learned counsels appearing heard the arguments advanced by the learned counsel appearing for the parties and have perused the material available on record. I have also duly considered the case law cited at the bar. The admitted facts are that the charge sheet was served upon the petitioner during the currency of the stipulated time period of suspension. However, the review for extending the suspension was done after the expiry of the 90 days period. Stop. Correct? This position is admitted.
My lord, admit. My lord, I apologize for the interruption, my lord. This, my lord, kindly one thing may be recorded that I have submitted another judgment, my lord. That is, yesterday I had submitted.
That is not in that list.
My lord, by separately I have submitted.
That's why probably I missed it. Which
Yes,
is that?
yes.
Just give that copy. I couldn't find it here.
Yes, yesterday I have submitted separately. That's why, my lord.
That's why probably.
That is, my lord, regarding the aspect that, my lord, the notification memorandum was not the.
Okay.
42 is a relevant parameter.
Oh, okay. This was at the end you had submitted.
My lord, my lord.
A third submission of Kotha Kuidia that he further submits that the office memorandum issued by the state respondent being contrary to the mandate of the apex court in Ajay Chaudhary Supra and the same being not issued under section 162, na? Article 162
and my lord, 163
and 163 of the Constitution of India cannot how did you start it?
Being contrary to the mandate.
No, being contrary no koba. Stipulating 6 months time for undertaking review after the charge sheet being filed within the currency of the 90 days period is not issued under Article 162 and 163 of the Constitution of India, and the same being contrary to the clear mandate of the decision of the apex court in Ajay Kumar Chaudhary Supra, is of no consequence to the respondents. Correct?
Being an executive instruction.
It means that only.
Man.
Inasmuch as the same being an executive instruction cannot change the mandate of the law. In support of the aforesaid submission, he relies upon the decision of the apex court in the case of Puneet Rai versus Dinesh Chaudhary, reported in 2003, volume 8, SSC 204. The reliance placed by the petitioner on Ajay Chaudhary Supra is misplaced. The said decision does not lay down any rigid or inflexible formula as to automatic lapsing of suspension beyond 90 days, but emphasizes the requirement of timely review with a view to preventing undue hardship caused by prolonged suspension. The state government has, in compliance with the principles enunciated in Ajay Chaudhary Supra, framed guidelines prescribing timelines which provide for review within 6 months in cases where a charge sheet is served within 90 days. This court does not find the said guidelines to be inconsistent with the ratio laid down by the apex court in the case of Ajay Chaudhary Supra. In the present case, as the charge sheet was undisputedly served within 90 days and the review was undertaken within 6 months thereafter, the continuation of suspension cannot be held to be illegal. The further contention regarding the competence of the reviewing authority is equally untenable, since the director land records and surveys, being the head of the concerned appointment and the appointing authority, was duly empowered to conduct the review. Considering the gravity of the charges leveled against the petitioner involving demand and acceptance of bribe, and the fact that criminal proceedings are pending against him, no equitable ground is made out for interference in exercise of writ jurisdiction. This court's view is fortified by decisions of this court, where the interplay between Ajay Kumar Chaudhary and the state's office memorandum dated 4/2/2020 has been considered. In Samsul Hawk Supra, the court held that where a charge sheet stroke show cause notice is issued, where the currency of the initial 90 days, within the currency of the initial 90 days time period and thereafter within the time frame contemplated by the said office memorandum, the suspension is reviewed and extended by a reasoned order, such extension does not offend the law, laid down in Ajay Chaudhary Supra. Relevant paragraphs of so and so Samsul Hanga reads as under. Paragraph 20. Reading of the aforesaid, it is apparent that it appears that the continuation of suspension beyond 90 days without issuance of charges or without any bona fide review is impermissible. This decision makes clear the legal test applicable to the facts of this petition. The critical elements are: number one, service of memorandum / charge sheet within the initial 90 days. Number two, a bona fide reasoned review, extension by a competent authority in accordance with the office memorandum. And number three, correct reckoning of dates when the suspension takes effect. Considering the above facts and circumstances of the case, I find that the suspension and the extensions thereof. No, I find that considering কি বুলি ক'লা? Of the case, especially keeping in mind that the impugned suspension is carried over after issuance of a charge sheet with extension by a reasoned order, comma. I find that the impugned suspension is legal and valid. What is the state of the disciplinary proceedings? With the hence the writ petition fails with no order as to cost and equity.
My lord, I am highly obliged, my lord. My lord, I have.
Sorry.
I am highly obliged, my lord. Only one aspect, my lord, I have submitted, my lord, affidavit that I have not, my lord, I have not submitted regarding this. Can be possible only to, my lord, record this, my lord, that. I have filed, my lord, affidavit. It was in record, my lord, but that document I have not placed.
Which document?
My lord, my lord, the FR has been submitted in the case. So can it be possible to, my lord, mention?
You have not said any time anyway. That doesn't make any.
Yes, obliged. Highly obliged.
The yardsticks are different.
My lord. Obliged.
এইখন লৈ ল'বা দেই।
Need to your worship.
34. This is from the supplementary list. The entire matter was supposed to be heard today.
My lord, it's a very small issue, my lord. The transfer issue, whether my lord public interest is involved or not. That is the question.
Yes.
Now, your lordship may like to see order of transfer that your lordship will get at page 13 of the writ petition.
Page
13, 1-3.
Yes.
This has been issued by the Deputy Secretary to the Government of Assam Labour Welfare Department. The petitioner before your lordship is a registrar. Now, my lord, by this order, the 20th June 2025. May I read the order, my lord?
This is page 13 is a order of the coordinate bench. That
no, page 13 is the, my lord, the impugned order of transfer in the writ petition.
Page 13 is
Your lordship
WPC 3585.
Perhaps your lordship is taking up the IA. I am coming to the, my lord.
Oh, yes. Yes. Written objection is also there.
Yes.
Affidavit or objection? This is
that is in the IA, my lord. That ought to have been in the other file perhaps.
Okay. এইবোৰ আমাৰ order sheets ৰ লগত কিয় গাঁঠি দিয়ে আজিকালি affidavits বোৰ? Huh? They should be kept in sequence, no? Yes. Page 13.
Page 13.
Yes.
May I read it?
Yes, please.
In the interest of public service, Sri Bidut Kumar Das, the private respondent, my lord, respondent number 3, Registrar Industrial Tribunal Dibrugarh is hereby transferred and posted as the Registrar Labour Court, Guwahati, with immediate effect until further orders. Vice Srimati Polly Post, the petitioner, Registrar Labour Court, Guwahati, transferred. Then in the interest of public service, Srimati Polikos, Registrar Labour Court, Guwahati is hereby transferred and posted as the Registrar Industrial Tribunal Dibrugarh with immediate effect.
Just 1 second. তুমি long judgment কেইটা পালা? 1. আৰু টেকাই 2টা. And ভাৰ্গৱে এতিয়ালৈ পোৱা নাই। Take us. Yes, yes.
So, my lord, the private respondent from Dibrugarh to Guwahati and the my lord petitioner from Guwahati to Dibrugarh. Now, my lord, this order also does not disclose, my lord, who has to, my lord, hand over charge first, who has to move first. That is not there, my lord, in this order. Now, my lord, I'd like
You
to
were
explain-
earlier in Dibrugarh.
My lord.
From Dibrugarh, now you've been brought to Guwahati.
No, my lord, the private respondent has been sought to be brought from
This Vidyut Kumar Das is the private respondent.
private respondent, respondent number 3.
R3. Ms. Barua,
Madam.
your client. Who is for state? I think you should come in that seat. Huh?
That was senior.
No, but this court would like to see the state stand, not the private respondent stand in a transfer matter.
I was listed.
Anyway, yes,
Now, my lord, I'd like to inform your lordship, my lord, in Assam. there
you are Polikosh.
Mine.
So you've been transferred and posted as so and so Dibrugarh. Okay.
Now, my lord, there are 5 posts of registrars in Assam, my lord.
Hmm.
2 posts in Dibrugarh,
Hmm.
2 posts in Guwahati, and 1 in Silchar.
Hmm.
So, my lord, these transfers are to be made, my lord. These are the 5%, the 5 posts where transfers are to be made. Now, my lord, this order I have challenged on 2 grounds. Firstly, my lord, there is no public interest involved in the matter. And secondly, that my stay in Guwahati is necessary for the education of my daughter, and I am a single mother.
Yes.
And while considering the, my lord, it was a request transfer, and my lord, while considering the, my lord, the request of the private respondent, my comparative difficulty has not been considered. These are the, my lord, basic.
Where is the request
My lord,
of the private respondent?
that's why, my lord, the records were
Records.
and in
That's
fact,
an admitted position.
in fact, my lord, in the objection to the my lord IA, they have also, my lord, admitted that.
But have you, at any point, have you expressed your reservation to move out because of your daughter's education and all that?
No, in fact, my lord, there were these transfers get, my lord, hardly these transfer orders are made, my lord. There was no occasion to transfer.
No, but otherwise, any representation or anything given?
No, my lord, because
Not given.
I am here, I am kept in Guwahati, my lord, and I am happy here.
No, after the order also, you have not given any representation.
After the order, my lord, the representation has been given. That is at Annexure B, my lord. Next page.
Yes.
Immediately, my lord, this the order of transfer is 20th of June. On 21st, my lord, she has
On the next date.
Then, my lord, she approached this honorable court, and your lordship may kindly see the initial orders passed in the petition. Initially, my lord, there are 3 orders passed. Firstly, that, my lord, no coercive action shall be taken on 2 dates. And on 30th of June, my lord, the order was, my lord, finally it has been, my lord, the transfer order has been stayed.
Against that, the vacation application. Yes.
Now, my lord, to bring home the, my lord, the point of, my lord, public interest is that, my lord, the request transfer cannot be made to look like, my lord, a transfer in the public interest. On that, my lord, I'll rely on a decision of the Honorable Supreme Court that, my lord, the request transfer, it cannot be a transfer in public interest. And, my lord, in that decision also, my lord, it has been said that the comparative difficulties have to be considered. That was not considered. And in fact, my lord, after the order.
Are you still working at Guwahati?
Yes, my lord. But, my lord, the fact remains that neither me nor the private respondent is getting salary. Now, what happened, my lord?
Private respondent has been released from his or her.
Yes, my lord. In fact, the in spite of the order of this honorable court recording that, my lord, no coercive action has been taken, my lord, in violation of the order, my lord, some orders have been passed. I'd like to bring to your lordship notice to that also, my lord. Because it was also that no coercive action had been taken. Then, my lord, there have been communications. And one particular communication, if your lordship kindly peruses.
No, why I'm asking this, because Mr. Bora, you see, prima facie, I don't see any ground for interfering with the interim order.
Your lordship
I'm yet to hear the applicant, but it's a request transfer. Now, the petitioner is also having certain difficulties. An application was made on 21st. The authorities could have considered it.
Let my senior complete.
No, I am on that. Why can't you look into the grievance of the
Lordship, if I-
petitioner? Because you see, apparent one thing undisputedly, one thing is that it is a request transfer.
Your Lordship, it's not a request transfer. Let my senior complete.
Have you submitted your affidavit here?
No, Your Lordship, records are itself will reveal everything. Everything, note sheets are there, everything are there. And
No, that's why. So I can, Mr. Chaudhary, I'll come back to you.
Right.
Ms. Barwa, yes, Ms. Barwa, what is your case? You are the IA to some in the IA. Yes, I'm taking the IA. What is your case in the IA?
Lordship, may kindly go to page 13.
Page?
Page 13. This is the order of the Honorable Court, Lordship.
Yes, that order we have seen.
Yes,
Yes.
27. The
Yes.
stay order was granted, Lordship.
Yes.
And before that, Lordship, I have already joined, Lordship, in the office of the Labor Court on 7/7, Lordship.
Hmm.
My joining letter is, Lordship, may kindly see.
You joined on when?
Handing 7/7.
No, but this transfer order is on 20 something.
26.
26.
Yes.
20.
26.
26, 25
25.
is the transfer order.
Yes.
And
Annex
the
of the
stay is 21.
21. Before that, I have already joined, handed in this office. Let's see if I kindly see page 16. This is Annexure D. This is the regarding handing over charge of register Industrial Tribunal Dibrugarh. I have already handed over the charge in Industrial Tribunal Dibrugarh, Lordship. So, last paragraph.
You have handed over.
Yes, I handed over the charge in Dibrugarh, Lordship.
That is the difficulty you are having.
Yes.
Yes.
Next page, Lordship, page 17. This is the certificate of transfer of charge.
So your ground for vacation is because pursuant to the transfer order, since you have handed over the charge,
And
and
joining report is there, Lordship, page 18.
5th July. You've joined where? In the
7th of July, Guwahati, Lordship.
In the Guwahati.
Yes. Page 18. Therefore, I pray to accept my joining letter and transmit the same to the Labor Welfare Department for necessary action. Page 18 is my joining letter. Report, Lordship.
And page 17 is what?
Page 7 is certificate of transfer of charge, Lordship.
Transfer of charge. Yes.
Page 18 is my joining letter, joining report.
Yes.
Page 20 is the acceptance letter, Lordship.
Page 20 is a?
Acceptance letters. That
This is 7th day of July.
7th day of
7.
July. Lordship. This is the written by presiding officer, Labor Court. That in can I read it?
Yes, yes.
Sir, we inviting reference to subject. I have the honor to forward here with the application dated 7/7 submitted to Bidyut Kumar Das, Registrar, Industrial Dibrugarh in person before the undersigned in order to allow him to join as registrar in the office of the undersigned. This is it is pertinent to mention here that since Polycos, the Registrar of Office of Labor Code, Guwahati has opted for earned leave with effect from 21/6/2025 till immediately after the transfer order, Lordship, till 10/7/25 without handing over the charge, and the fate of her leave application is not known as of yet. As a result of which the post of registrar is lying vacant in the office of the undersigned, and as such the joining of Sri Bidyut Kumar Das is accepted accordingly. This is for your information and urgent necessary action. That
Yes.
was accepted. Next, page 21 is the pay slip generated by the Lordship, the AG office. Pay slip in my favor as a registered labor code. 4/8/2025.
Yes.
Lordship, page 22 is the order, Lordship.
What is this order? This is after the High Court's order.
Yes, 1st of August. This order, Lordship, may I read out, in application of Sri Poly Court wherein she has stated that she may be allowed to join as registrar in the Office of Labour Court, Guwahati, as she has completed her period of earned leave. She has also brought to the notice of the undersigned with respect to the order passed by the Honorable High Court, whereby the Honorable High Court, by order dated 21/7/5, has directed the labor not to give effect to the impending transfer order till the next date fixed. Considering the fact that since the post of registrar in the office of the undersigned was lying vacant, since the day she went for medical leave without handing over the charge, the application of the Sri Vidut Kumar Das was taken into consideration as per the orders of the government of Assam, and he was allowed to join as registrar in the office of the Labour Court. However, Sri Poly Court filed application dated 31/7 has submitted her joining report along with her medical documents, but she has not brought to the notice of the undersigned as regards to the leave granted later by the appropriate authority. She was not granted the leave, Lordship. So, authority as well as her handing over the charge of her leave availing periods. In view of the above, she is directed to approach the undersigned with the documents as mentioned above. In the meantime, the application data will be forwarded to the Labor Welfare Department, the schools, for necessary information and action. Page 23 is for presiding officer to deputy secretary. And he has written that the fact, Lordship. Paragraph 4, paragraph 3, Lordship. Last May, therefore, considering the grounds shown and also taking notice of the fact that post of registrar in the office of Labour Court was lying vacant as the former registrar office of the Labour Court, namely the Poly Court went on earned leave without handing over the charge. And the application of Vidut Kumar Das was taken.
All right, I've read till 24. Now, everything is before the deputy secretary to take a call.
Yes.
This particular writ petition has become infructuous by 21/7. Why I say so? If your lordship peruses through the earlier orders, the first order itself, where
Just 1 second. At page 24, it appears that this letter was addressed to the deputy secretary of the government of Assam to solve. Now, what is the order of the deputy secretary? What did he do after this?
it is lying because since the matter is sub judice before your lordship, and
No, but you see, Mr. Barua, infractions and all these technical submissions you make it, but it looks like that the state has also not taken any action because it appears that 2 officers are now suffering. Now, who is at a fault and not, that is, this court is not concerned, but they both are also not getting their salaries.
Your lordship.
Now, and it appears in one hand, it appears one of the petitioner had obtained a stay order from here, whereas prior to that, the private respondent had already joined. These were the things which the state government council should have pointed out before this court. That was not done. All right, even if it was not done, subsequently it was whose duty? State should have come up before this court instead of making this mess. Now, the labor officer has, the presiding officer has correctly said in page 23, he is under predicament what to do. There is an order of this court one side, on the other side, one person have already joined prior to that.
Yes.
And then he writes a letter to the deputy secretary that you are the registrar, now you give us a solution. He is also sitting idle.
Your lordship, if I may.
You should have come up with some application for clarification or whatever.
Your lordship, if I may just state.
And where is your affidavit? Affidavit also not on record.
Your lordship, if I may just state the facts. facts are such that the matter, when it came up before your lordship for the very first time, just before the summer vacations, on 25/6/2025, I appeared before you on behalf of the government. Now, the government, the Honorable Court did not stay the effect of the impugned transfer order. I was directed to produce the records. Now, in terms of the particular direction, the court also asked me not to take any coercive action. And coercive action was not with regards to stay the effect of the transfer order. That is because I don't have the authority to stay the effect of a
Mr.
transfer order.
Counsel, the difficulty is that you simply do not want to understand what the court said. There is an order which says that the transfer order shall not come into effect, correct? That order has come. Ultimately, later on it has come.
Later on, it has
But it has come.
Your Lordship,
It has come or
has
not?
come. It has come.
Now, because of that order, all these difficulties are happening.
Now,
Yes or no?
yes, I agree. Now,
No,
only
then
on the basis of my undertaking that no course of action vis-a-vis the petitioner, because the petitioner, as per one particular OM, if I may place that particular OM before your lordship, as per that particular OM of 2024, if any government servant does not join the place of posting, then disciplinary action, strict disciplinary action.
that you take whatever you want to take. I am
But
not on all
only
that.
on the basis of that particular submission, no disciplinary action has been taken till date against the petitioner.
You have also not come seeking liberty to to go ahead and take action against the petitioner for going on for unexplained leave or
Your Lordship,
you have not taken that.
I got the instruction. The interim order was passed on 21st of July. Immediately, I wrote to the department concerned that kindly provide, because as my learned senior has raised this issue, that
So in the records now, what do you have?
so just produce the record, Your Lordship. Also the instruction of 12th August. And one judgment of the Honorable Supreme.
Judgment later on.
Later on.
I am not hearing right now. Yes, two documents. What do you want me to see first? Which is records? Where are your records? This is records. Since when records have come without files, file covers, nothing? These are a bunch of some papers.
Now everything is in e-file. That's why the note sheet and everything is there. The first note sheet, the flag mark A, it starts, Your Lordship. And if Your Lordship goes to flag mark 4, flag mark D, that is the minister's approval. And prior to that, in fact, everything is there as to on what basis, how this particular decision came to be taken to transfer the private respondent. And it is not the case, Your Lordship, that the petitioner's case was
Which is the document you want me to see first?
the
Place the records.
flag A, Your Lordship. Flag A.
That's A.
Flag A, Your Lordship.
I can see BC. It's coming from the back. BC.
Flag A, Your Lordship.
There is no flag A.
Flag A is there, Your Lordship. If I may just.
What does the flag A? Oh, the first. No, this is the front page. This is flag A.
Flag A, Your Lordship.
This, yes.
There's a front page of the whole note sheet.
That I've seen.
Yes.
Now,
After that, Your Lordship may kindly come to flag D, wherein the minister's approval has been taken.
B.
D.
Yes.
On what basis that the whole decision was taken? Prior to the minister's approval, the whole fact sheet has been written. The note sheet after note sheet. Yeah. Here, the petitioner has been in Guwahati for the past 13 years, Your Lordship. That fact has not been actually highlighted by the petitioner, but the petitioner has been.
As a counsel, if you want me to read, I can read.
Yeah.
If you want to submit, then I will hear. Now choose. You want to submit or you want me to read?
Your Lordship.
Because I cannot do both the things together.
Yes.
You may be able to do it. I don't know about Mr. Chaudhary and Decca, but I can't. What is this annexure B that you wanted to show me? This is an office memorandum which says that if a employee has been transferred, then he or she has to first join and then submit a representation.
In terms of SC Saxena judgment of Supreme Court.
That is all right. You see, Mr. Barwa, now the fact is that there has already been a stay. A stay has already come. And because of that stay, a situation has also arisen. Because prior to the stay, the private respondent has already joined while the petitioner was on leave.
Then your lordship may kindly.
Now, in order, you see, either this court will reject the vacating application today or vacate the stay. To do any of the course, the court has to apply the court's mind. It cannot be a mechanical exercise. The other way is to hear this entire list, but for that, you have not filed your affidavit till now.
Lordship may then grant me some time to file.
The affidavit has to come.
Yes.
This is a matter. How can this matter be disposed of on the basis of these materials?
Your lordship, then I may be directed to file the affidavit. And also liberty may be granted to file a stay vacating application.
Why do you need that liberty from this court? You need a liberty from this court for filing a stay vacating application, Mr. Counsel?
Otherwise, no.
That was the first thing you should have done before, because evidently there has been a situation where both the persons are before this court is not getting their salaries. Instead of the private respondent rushing to the court with a vacating application, you should have filed it. This document doesn't say anything. Where are the reasons in here? Please point out the reasons of transfer of the petitioner.
Next instruction, 12th August. Because on last occasion,
This one?
Yes, 21st of July, this issue was raised regarding whether there is a private interest involved or public interest involved.
This I've only read the first note. It only says basically it is in reference of the Mr. Chaudhary was very right when he said that it was a request transfer, because the entire thing started because of the application given by the private respondent, wherein the private respondent has highlighted the problems of the private respondent, correct, in relation with his kid and his ailing mother. Now, considering all these reasons, there was the government found that out of the two persons who are the registrars of labor court, one had been there for last 8 years and the other one for 13 years, and accordingly the petitioner was transferred out because petitioner had spent about 13 years already. But the fact remains that even the petitioner has certain personal problems. Now, these were brought to your notice immediately on the second day. What did you do after
Your
that?
lordship, that particular problem as such, I highlighted.
That is for that OM that you are saying.
No,
that
no, no.
first.
Regarding the problem, she had highlighted two problems. One is basically her daughter, who is pursuing LLB, and that too in Delhi. She's transferred from Guwahati to Dibrugarh. Her daughter is studying in Delhi. That has got no correlation for sure.
Anyway,
But
Mr.
anyway,
Chaudhary, this matter would require a full-fledged hearing. The government has to file the affidavit. Otherwise, you will not get a chance to revert. That would, at some point, it might prejudice one of you. So I don't think it would be correct. But I am obviously not considering the situation. What I propose to do is that to say status quo as regards this post. Whoever at present is holding it, will hold. So I am not entering into all this.
My lord, that is fine, my lord, but before that, my lord, before your lordship passes the order, may I draw your lordship's to attention to my lord, two documents, my lord, basically. So far as that, my lord, request transfer is concerned, my lord, that has been admitted in the objection they have.
I've seen it also.
Your lordship has seen.
Hmm.
If your lordship kindly comes to the my lord, objection in the IA, my lord.
Objection in the IA.
No, my lord, in my IA, my lord. My IA.
You also filed an IA.
No, he's IA for my lord. IA for your lordship was reading that. IA for vacating the interim order.
In IA, there is no written objection. Oh, that objection which was kept in the writ petition.
No, I want your lordship beat the my lord IA. The IA, I don't.
IA is 2985.
Yes,
I have it. What do you want me to read from here?
yes.
Page?
Your lordship may kindly come to page 16, my lord.
Page 16.
Because, my lord, I have also LS Melaf ID because I don't know, my lord, who is the person behind.
I am not entering into the merits right now because it will not be possible to adjudicate the entire thing like this without the affidavit.
At the same time, my lord,
So-
your lordship is considering
And the
IA.
fact, you see, the fact that if the private respondent hadn't joined prior to that order, of course, this court wouldn't have vacated the stay. Now, the fact that has already been joined. So, without going into who has joined, who's not holding, I will simply modify the interim order by saying status quo to the post of so and so,
My lord,
as on today.
that's fine, but my lord, your lordship will also take into account the fact that, my lord, there was an order not to take any coercive action.
That you have to adjudicate later on. Today, I'm not entering into all this. I'm sorry, Mr. Chaudhary. Because, see, this way, both of you are suffering. Both of you are suffering.
My lord, when there is
Now I have to
my-
balance between the
my
two
lord, my
equities.
submission-
What else do you,
One-
what can be done right now? Unless, of course, the government had filed the affidavit and endeavor could have been made to just finish the hearing. But this way it would prejudice you, I'm telling you.
My lord, but
Because the records I have seen. Let them put their affidavit so that you get your chance.
I am obliged for that,
Yes.
my lord. What I want to point out is that, my lord, uh, mm, the fact that, my lord, this honorable court has passed an order.
I understand that
Saying this-
initially not to take coercive action.
Yes, my lord. Then, my lord, when this order is there, my lord, staying the order of transfer, the, my lord, respondent has to go back, my lord, carry out that order. That is my submission. I will not, my lord, take your lordship's valuable time. Because rightly or wrongly, my lord, there is a stay order. Subsequent to the, my lord, order of no coercive action, my lord, in violation of the, my lord, the order of no coercive action, my lord, the.
Where is that order in the main writ?
that order itself, your lordship, order dated
Mr. Chaudhary, what is the order date?
25/6.
25/6.
Was the undertaking given by me. That no course of action will be taken against them.
And, my lord, ground. they have
All right,
taken
Mr.
is
Chaudhary.
That, my lord, the since I am on leave, the post is vacant. Can it be vacant, my lord? And the private respondent has taken charge and handed over charge to whom, my lord? One document showing that I have taken
Anyway,
over and handed over.
All right. Heard Mr. M.K. Chaudhary, learned senior counsel, assisted by Mr. N. Deka, learned counsel for the writ. Sorry, I hate Lekha. I always go by the sides. First Lekha heard M.S.R. Bora, learned counsel, appearing for the applicant. Also heard Mr. M.K. Chaudhary, learned senior counsel, assisted by Mr. N. Deka, learned counsel, appearing for the respondent stroke writ petitioner, and Mr. D. Bora, learned counsel, appearing for the official respondents. Hey, who had typed this order? I clearly remember I said N Deka, it's written M Deka. তোমাকে initial গড়বড় করে দিয়ে চাবা এবার। By way of this interlocutory application, comma, the applicant is seeking vacation stroke modification of interim order dated 21/7/2025 passed by this court in WPC 3585 stroke 2025. The order dated so and so, the operating portion, the relevant portion of the order dated 21/7/2025 reads as under A to A, it is directed to, 15 or like. Shall not be given effect. MS Bora, learned counsel appearing for the applicant, submits that pursuant to the impugned transfer order passed on 26/2025, the applicant handed over charge of Registrar Industrial Tribunal Dibrugarh on 5/7/2025. And accordingly submitted joining report before the before the presiding officer, Labour Court stroke Guwahati on 7/7/2025 to join the new post in terms of the said transfer order. She further submits that by order dated 7/7/2025, the presiding officer stroke Judge Labour Court Guwahati on 7/7/2025 accepted the joining of the applicant. She further submits that pursuant to that, she has also received salary from the office of the transferred post, correct? This page 21 is that, right, Ms. Borua? Payslip.
Payslip.
Top.
But he has not received the salary.
Okay, payslip. She further submits that payslip also thereafter has been issued from the don't say that. Mr. M.K. Chaudhary, Learned Senior Counsel, while opposing the prayer for vacation stroke modification, submits that the impugned transfer order has been purely done on the basis of the request made by the petitioner and no element of public interest whatsoever is involved in the impugned transfer. Stop. He further submits that though this court, while issuing notice in the writ petition, had directed the respondents not to take coercive steps against the petitioner pending adjudication of the writ petition, it appears that by allowing the private respondents to join the transferred post has taken coercive steps against the petitioner in defiance to the judicial order passed by this court. Correct? That was your submission?
My lord, only one thing, my lord, that my submission that they'll not be petitioner, it will be applicant, my lord.
Sorry. I think because of the sides, I'm getting confused.
Which side will be? Say that
Because on the other day, she was this side and I made her go that side. So today she's very consciously standing that side. Yes, a applicant. Stop. Then Mr. D. Bora, learned Government Council, has placed the records. Perusal of the same indicates that as per OM dated 25/11/2024, once a transfer and posting order has been issued, the same is required to be given effect by the employee, by the officer concerned without any delay, and any representation, if any, shall be entertained only after he/she has joined in the new place of posting. It further appears that the impugned transfer appears to have been made keeping in mind that the petitioner has served 13 years, more than 13 years, more than 12 years in the Labor Court, Guwahati. Stop. Be that as it may, the records, be that as it may, the issue involved in the writ petition has to be examined. The same is not possible without the respondents filing their respective return. Having considered the materials available on record, this court deems appropriate to modify the interim order passed by this court on 7
21/7.
That order has gone missing. So many orders. 21/7, 21/7/2025. To the extent that status quo to the post of where is that impugned transfer order? I just want that post. To the post, yeah, I've got it. To the post of Registrar Labour Court Guwahati shall be maintained pending adjudication of the writ petition. I stands disposed of. In the main case, you say, yes, how much time? In the main case, if I MK Chaudhary এইটো side কৰি তেওঁলোকে এফালে কৰা that as prayed for by Mr. So-and-so Bora seeks 2 weeks time to file return in the matter. Yes, you want to also file there or you filed in the writ? You will not file. So-and-so and so-and-so, 2 weeks. Keeping in mind the interest, keeping in mind the urgency canvassed by the learned counsel appearing for the petitioner, the return shall be positively filed by the next date of listing. Yes, when do you all want it? List on such and such date.
Immediately after vacation, whatever my lord date my
আৰু এটা কথা কৈ দিবা that it is submitted at the bar that in view of the interim order passed, both the petitioner as well as the private respondents are not getting their respective salaries. এটো মই অকমান edit কৰি দিম।
Item number 17.
Should I add one that in case when you're at liberty to join your new post without
No, my lord.
no need.
Because, my lord, my submission in the final hearing will be that, my lord, when this order has
All right,
been
all right,
passed,
all
my
right.
lord. stay.
Otherwise, I would have protected you that much that without
In fact, my lord, my submission would have been, my lord, that she should go back because the transfer order has been stayed.
all right.
One thing
On that, my lord, I'll rely on.
All right,
decision.
all right, all right, all
I
right.
submit Lordship, this is my last leg of posting. I am going to be retired after 1 year.
All right,
That's why I had made the
all right,
application.
all right, all right, all right. But Mr. Bora, you please look into the issues with some humanitarian angle also. Yes.
The department will.
All right, next.
Time being item 17.
Yes, Mr. Sharma. I don't think I have, I think I've already disposed 3 lengthy judgments today. Now, because this I remember is another case which otherwise you have completed your hearings. It was only for
the records for the resolution.
yes.
Some judgments, my lord. My lord,
I think on another date this matter can be taken up because let me have it on a date when I can
Yes,
dictate the judgment.
Yes, ma'am.
Otherwise, it will be of no use.
Yes, ma'am.
can
Um,
it be next Tuesday, my lord?
Mr. Sharma, this is the branch which you had given.
Yes,
huh?
madam, the
This is
compilation.
this is the whole compilation.
In fact, all the cases which have been cited, my lord, have also been appended, my lord.
Mr. Fukan, where is your documents? You were supposed to show something. The records, I think.
Dual judgments, my lord.
Then give that list. You give that compilation.
My lord.
You give that compilation. Mr. Sharma has already given us the compilation. You give your compilation because hearing otherwise is completed. Anyway, heard Mr. M. Sharma, learned counsel appearing for the petitioner. Also heard Mr. P.J. Fukan, learned counsel appearing for the respondent. Mr. Fukan shall submit the
Judgments, my lord.
submit a short note of the offence taken as well as the cases relied upon. Relist on such and such data. That did you?
On Tuesday, my lord.
Pariban and file on Tuesday, নহলে Wednesday. Wednesday.
25th. I'm grateful, my lord. Most.
You give this before Wednesday,
My lord.
that list.
My lord.
Item 15.
Obliged.
None appears for the petitioner on call, relist after 3 weeks on a date to be fixed by the registry.
Item 16.
Yes, 16.
Item 15.
Why? What happened?
Sorry, Lordship. This part of it, password of matter.
Okay, as prayed for Croatia. All right, 16.
Item 16.
Lordship, in this case, Lordship, the contender respondent should have to file their reply, Lordship. They have not yet, Lordship.
Huh?
The respondent contender, Lordship, has not filed their reply, Lordship. Last occasion.
Who's appearing for the contempt now? Yes. Respondent counsels A. Fukan, R. M. Bora, Barwa, S. Chutia. No one is there today. What to do, Mr. Majumdar?
Lordship,
Contempt cases are now no more taken very seriously in this court, looks like. Very sad state of affairs. Something has to be done.
Lordship, I pray, Lordship.
Why? But maybe the councils may have,
Other way, Lordship.
because some judgments were, orders were also fixed at 2, perhaps because of that they are not here. Otherwise, they are generally here, the lawyers. All right. Heard Mr. KM A. Majumdar, Learned Counsel, appearing on behalf of the petitioner. None appears for the respondent contemners on call. It appears that the affidavit and the affidavits
Of the respondent content.
are also not yet filed. Relist after 2 weeks on a date to be fixed by the registry. It is needless to be clarified that if the affidavits is not filed by the next date of listing, consequences in accordance with law shall follow.
Item 20.
This is for this is in the orders or hearing or negative?
It is hearing, my lord.
Yes.
But perhaps lordship today, I think it's fixed for some report was.
Some report, you don't know what. Why is today? Why the matter is fixed today? You don't know.
No, that is fixed for hearing, lordship, but today anyway.
No, today what? You are saying for some. What some? I'm asking you.
No, lordship, I am not the, as per last order, some inquiry report was, thinking was.
Which order? Inquiry report. It has come.
Yes, sir.
In report process. Yes. Just open the steps. Stapler, no, pens. Get hurt. Paper. The report has come. The signature is confirmed of Dr. Ramen Talukdar. Only thing, the place is not, the place of signing, that is not confirmed. But this is confirmed that it is his signature. So I think we'll fix it.
I have filed a petition for withdrawal of myself as an advocate from this case, as because some differences is arising in between.
You are Mr.
I am Zaid Suikia.
You are Jay Sirkia. And so you are for the respond number 3.
Yes.
Okay. I think we will take this on record and we'll fix it on another date. And this report can be given to the parties, I think. So that you haven't, all parties will get to know. So, like, heard Mr. So and so learned counsel appearing for the petitioner. Also heard Mr. J.S. Saikya.
J.H. Saikia. Zakir Hussain Saikia.
Ikoluma. J.S. Learned counsel appearing for respondent number 3. And Mr. S. Bhuya.
Higher Division 1 and 2.
Learned counsel for 1 and 2. 1 and 2. It appears that pursuant to the order dated 12/8/2025, the Registrar Vigilance has made an inquiry into the complaint filed against Mr. J.S. Aikya, Learned Counsel, to the effect that the additional affidavit filed on so and so is not under his signature and has submitted a report in seal cover. Upon opening the seal cover, this court, after going through the report submitted by the Registrar Vigilance, Guwahati High Court, Guwahati, finds the following findings, quote unquote, page 7 to mark. Let a copy of the report be furnished to the learned counsels appearing for the parties. Released after 2 weeks. After 2 weeks on a date to be fixed by the registry.
Date be fixed because there was.
It will come. Yes. The preliminary inquiry report be kept on, I think it can be kept on record. Kept on record and marked as X.
Beg your indulgence, my lord, in item number 16, my lord.
Yes, Mr. Fukan.
I was on Lex in.
Yes. So that is why we didn't take any steps. Your name will come, but only thing you file your affidavit by the next date. Otherwise, adverse consequences will follow.
I am actually for the respond number 2, my lord. 1 will be filing. My lord, my name may be required.
You are for?
I am for respond number 2, my lord.
2 koridiba.
Item 16. Deeply obliged.
25 and 26.
Mr. Saikya.
These cases, my lord, we have been engaged recently, my lord.
All right. Another date. As prayed for by Mr. So-and-so on the ground that he has been recently engaged in the matter, which is not opposed by the other side, relist after 2 weeks.
23rd, my lord.
Not be possible.
30th, my lord. 30th.
No. October. October, yes. 30th?
Name may be recorded.
You want your names to be recorded, then you give an appearance slip. Yes.
27.
May previous your lordship, my lord. My lord, here, my lord, the petitioner side has recently, my lord.
But where is the petitioner side, Mr. Sharma? I can only see the respondent side. Das, sorry.
My lord.
Huh? None appears for the petitioner on call. Relist after 2 weeks on a date to be fixed by the registry. Mr. BK Das to deliver the appearance.
Obligation.
Yes.
29.
Yes, Mr. Chaudhary, you are still there.
Yes, my lord.
I remember you were here at 10:30.
Yes, my lord.
Huh?
Yes, my lord. My lord, what happened in the instant case, my lord?
Yes.
Lordship, in this case, K. Gogoi is appearing, Lordship. And
All right, we'll have it after the vacation then. The hearing matter.
That may be fixed.
yes,
Heard Mr. NNB Chaudhary, learned counsel appearing for the petitioner. A mention is made on behalf of Mr. K. Gogoi.
K. Gogoi.
K. Gogoi,
Okay.
learned,
As we are.
no, learned CGC or what? This
Higher
is
education.
learned Standing Council Higher Education. In view of the on the accordingly relist on such and such date after vacation. The date detail. Yes, Mr. Chaudhary, any specific date you want?
My lord, can it be, my lord, 14th October, my lord?
That is too near.
All of us are doing something.
Acha, have it. Okay. All right, Mr. Chaudhary. Yes.
Item 30.
Slow, slow, slow. Don't break your leg here. Mr. Chalia, Mr. Das, to be very honest, I have to disposing 3-4 long judgments. I am, and we are already at the
End of the road.
end of the day. I think it'll.
Sometime, my lord.
That's right. I remember this court had heard to an extent, I think, a little bit, isn't it, Mr. Chalia?
Yes.
You had started, I think.
I had started.
Correct,
finished
correct.
My part.
So when can we
Only-
have it?
My request will be on the next date fixed. I request your lordship to fix the matter at 2 p.m.
All right, that we can do it. Then we can have it after the reopening only. Because next week is the motion week, it will not be possible.
That's true. That is true.
Only 1 week is there. And a date, yes, you can suggest a date and heard Mr. DP Chalia, Learned Senior Counsel, assisted by MS
M. Roy.
M. Roy, Learned Counsel for the petitioner, and Mr. N.C. Das, Learned Senior Counsel, assisted by Mr. A. Das, Learned Counsel for the respondent numbers 2, 3, and 4. Due to paucity of time, hearing could not be completed. Relist on such and such date at as a fixed item at 2 p.m. Subject, of course, to the availability of the bench.
That will be always there.
I don't know. No, that's why I'm saying I'm going to fix it too, but who knows, I'm going to be sitting single or division bench or before another station. So I don't want the registrar to be at some kind of of course, outstation nowadays there is no difficulty because we can have it through video conferencing mode. So that there is no difficulty. But if there is a division bench, then 2 o'clock might be difficult, then it will be after the rising. So that is why I said. Because I don't know the roster after the reopening.
After opening.
It's a part of your.
For further hearing. All right.
31.
Yes, Mr. Gupta. Termination.
Without following any newspaper, natural justice, my lord, no show cause notice.
Your lordship, we have just filed the affidavit. It is on record. Affidavit on behalf of respondent number 4.
You filed it on 11th.
And in fact, they have not been discharged. In the affidavit itself, everything is clear. At paragraph number.
Not discharged.
Then in that case, my lord, why they are not taken back?
Do you obtain your specific instructions
No,
or
my
not?
lord,
Paragraph number
They
6.
have been, well, what happens, my lord?
Anyway, we will have it on another date. Now there is no time.
My lord, may I pray, my lord, this is small, my lord, my only.
After the vacation, not before that.
My lord, without salary, my lord, they
Heard Mr. H. Gupta, Learned Counsel appearing for the petitioner. Is that 24 matter, Mr. Gupta?
No,
We are having it fixed for hearing. It's already 4 o'clock. There's a full court meeting now.
my lord,
I said after the reopening. So why are you repeating the same thing, Mr. Gupta?
my lord.
Huh?
No.
This court have said that this court is going to give you a fixed date after the reopening.
No.
This court only have asked you to suggest a date.
My lord,
Heard Mr. H. Gupta, learned counsel appearing for the petitioner. Also heard Mr. D. Bora, learned so and so. Mr. D. Bora submits that by an affidavit in opposition has been filed recently, and in the affidavit in opposition, a specific stand has been taken on behalf of the state respondent that the petitioners has not been discharged from the service
From the
which
home guards role.
from the home guards
Role.
room
Role.
role as contended in the instant writ petition. Be that as it may, relist on such and such date for hearing.
My lord, 160.
Yes.
Like,